Open the hearing on Senate Bill 573 to establish a committee to study consent confidentiality laws regarding young people in healthcare, and the chair recognizes the chief sponsor, Senator Ward from District 8.
Good morning, Chairman Pearson and members of the committee. As amended, this bill would establish a committee to study consent and confidentiality laws applicable to adolescents and young adults' health care in New Hampshire. The membership of the study committee would include 2 members of the Senate and 3 members of the House. The study committee will be tasked with 1, reviewing current New Hampshire health care consent laws, including circumstances where parental consent is not required by law. 2, reviewing New Hampshire confidentiality laws and identify what protections exist for health care information for minors in New Hampshire. And 3, assessing whether any areas of health care in New Hampshire are not currently covered under existing parental consent laws and do not currently fall under existing New Hampshire or federal law exemptions to parental consent for medical care. This bill was brought forward to resolve a growing, alarming, and inexcusable threat to parents' rights in New Hampshire. As I expect some members of the committee already know, parents around the state have increasingly reported that their children are being given medical treatment of various kinds by public authorities and private medical practitioners without parental consent, treated in secret, or in the most truly bizarre cases, treated contrary to a parent's express wishes. In late 2022, the Nashua Department of Public Health administered the flu vaccine to a 7-year-old girl with no parental consent form. When he was asked about this event, New Hampshire State Epidemiologist Dr. Benjamin Chan publicly described this incident as a never event, a medical term for a breach so rare and severe that it should never occur. But it was not long before it happened again, this time even more egregiously. In October of 22, the mother of a 5-year-old girl in Rochester was asked to sign off on her daughter's flu vaccination. Instead, the mother gave written notice to the school stating that her daughter, quote, "will not be getting this shot. Please, I do not consent." The school received the notice and vaccinated her daughter anyway. I mention this case in particular because State Representative Jim Kofod personally reviewed the documents supporting this mother's account. In our legal system, parents have always been understood to have a natural and constitutional right to direct the upbringing of their children. Limiting that right has always required some specific evidence that individual parents are failing in their responsibilities. Yet these reports are only one part of a disturbing trend. Public institutions especially are increasingly infringing on parental rights by effectively declaring all parents guilty until proven innocent. Parents' rights are being steadily stripped away by default and entrusted to state institutions. Schools and other public institutions may sometimes think that they are more trustworthy than many parents, but state employees and officials are every bit as human as the most irresponsible parent, and people with power, if left unchecked, have always been able to do greater harm than people without. This study committee will allow the legislature to examine if our current healthcare consent and confidentiality laws have failed to adequately protect parents' rights. Thank you.
Thank you, Senator. Any questions for the senator? Vice Chairman Long.
Thank you, Mr. Chairman. Thank you, Senator. The question I have is, does this include mental and behavioral health, or is this just physical?
I don't, as far as I know, it's just the medical health, and the kids in school are being treated without parents' knowledge.
Okay, so
And it
follow
may
up,
include mental health, but I'm
yeah,
not sure.
Follow up on
Follow
me.
up.
In the act where it says laws applicable to adolescent and young adult health care. Young
That's what the
adult
bill
is
says.
is the 18 to
26?
is
That-
the 18 right? And I'm wondering, they call their own shots, don't they, with respect to their medical
Are you
health?
talking about the definition of a young adult?
Yeah.
I'm not sure. I've seen it up to the age 26, but it may be too high.
Okay. Thank you.
While such a study committee could conceivably discover lapses in the system, could it also be able to say that on ever so many occurrences, the system is working well? In other words, there is not necessarily a prejudice towards one conclusion or the other, but let the discovery go where it might?
I would certainly hope so, because I think whenever you do a study, you like to find out the plus and minuses, and you have to look at both of them and see how they weigh at the end.
I appreciate follow-up. I appreciate that because not all study committees come in with that motive. Thank you. Any other questions for the senator? Seeing none, thank you so much for your testimony. Is there
Thank you.
anyone else who, thank you, wishes to testify to this bill who has not signed up a pink card? Seeing none, thank you. Okay, with the leave of the ranking member, I close the hearing on Senate Bill 573, and I now open the executive session on the same, and the chair will entertain a motion. Who gets to write the blurb? Oh, is he going to make the motion? Say yes, Mr. Chairman. That's close.
I'll move OTP, Mr. Chair.
Okay, today's 4/23/24. The bill is moved by Vice Chairman Long and seconded by Representative DeSimone. Any further discussion on the bill? Seeing none, when the clerk is ready, please would you call the roll? The motion is on Senate Bill 573 FN, moved by Vice Chairman Long and seconded by Representative DeSimone.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon.
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman is absent today. Representative Levesque,
Yes.
Representative Petrino will be voting yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Gibbons, absent, and Representative Raymond.
Yes.
Motion carries 14-0 with 2 absent.
13. With 2 absent and 15 people, it's got to be 13 to zip.
We have 16 people.
We do?
Yes.
When did that happen?
When I signed on.
Oh, okay, so since the beginning. Okay, this shouldn't be recorded. Like someone said, 14-0. Okay. Thank you. You know, this is the first time in over a month I've had the children and family law gavel. Whoops. As you know, the speaker often asks for my suggestions on people who might like to serve on committees. So I would like to write down anybody from this committee that could be considered to serving on the committee this bill will establish. Do I have some takers? I see Long, Levesque. Got to write the letters, but don't say them. Okay, there it is. And anyone else? Representative Ball? Okay. Just Representative Perez. This doesn't guarantee an appointment, but it guarantees good consideration. Representative Gregg. Seidel? Oh, we got a nice group of people here. Okay, then if you could write the blurb, and this concludes the exec session on Senate Bill 573. Thank you so much. The next bill cannot be heard until its advertised time of 10 o'clock.
Mr. Chairman, may I?
Yes.
Since we have a couple of minute break, I just want to let everyone know in that little room, I brought donuts from a bakery in my town, so everyone is welcome to have a donut.
And,
You got 10 minutes?
and you can't eat, the bad news is you cannot eat them in this room. Sure, you can eat them in my office
Well, in the back room, we could eat.
or the
food.
back room, 2 of them.
And I can second how delicious those donuts are. Yes, Donut Fresh in Milford.
Okay, lead us out, please. It's an F. I open the hearing on Senate Bill 463, an act expanding access to court-appointed counsel for children in dependency proceedings, and the chair recognizes the bill's prime sponsor, Senator Carson.
Good morning, Mr. Chairman, and good morning, members of the House Children and Family Law Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, which comprises the town of Londonderry, Hudson, and Auburn. And this morning, I have for your consideration Senate Bill 463, which seeks to expand access to court-appointed counsel for children in dependency proceedings. This bill also makes various changes regarding the appointment of counsel for children, including the right to an attorney in certain situations. This bill further establishes new classified positions within the Department of Health and Human Services and makes an appropriation to the department. Why do we have this bill, and why do we need this bill? Well, children are the central parties in abuse and neglect cases. I think all of you that sit on this committee are well aware of that. You've heard, I would imagine, a lot of testimony about children and what happens to them when these cases come forward. And I think we all know too that these are some of New Hampshire's most vulnerable children. And the potential consequences that they face, including the loss of their parents, their homes and families, are severe and life-altering. So what does this bill do? It amends the New Hampshire's Child Protection Act to give family division judges the discretion to appoint counsel for children at any time in abuse and neglect cases. Under current law, courts may only appoint counsel for children in abuse and neglected cases in very limited circumstances. However, situations may arise at any point in an abuse and neglect case in which a child's welfare would best be served by the appointment of counsel, regardless of whether the child's expressed wishes conflict with the guardian ad litem's recommendations. And this bill provides more flexibility for courts to determine whether and when to appoint a counsel for children. It also adds a new provision to the Child Protection Act requiring mandatory appointment for children, appointment of counsel for children who are placed in or at high risk of placement in any group home or residential child care institution as defined by RSA 170E:25 or certified by the Department for the Care of Children pursuant to RSA 169C or in any state-operated residential treatment program. So this includes children being placed, as I said, at residential care, both in and out of state, because I think we all know that we do place children out of state, and one of the things that we're trying to do is to bring them back here to the state of New Hampshire. But we also realize that we don't have sometimes the type of facilities that a child really needs. It's a very unique and different situation, and those are the kids that are being placed out of state. I believe we had a Child Oversight Services meeting last Friday, and I believe we were told there's either 2 or 3 that are currently placed out of state. But we're really trying hard to keep them here or just to get them treatment here. So just to kind of give you that kind of an update. We know that these children, when they're placed in these types of setting outside of their homes, they're removed from their schools, their communities, family, and friends. And I'm sure you all know of the story of what was going on at Bledsoe Academy. Our child advocate is here, and I'm sure she'll go into that in more detail. This bill would require counsel for a fraction of children in child protection cases. I believe that you folks dealt with House Bill 535. This bill reins it in, makes it much tighter. Just to kind of give you just an idea, because we still have House Bill 535. That bill we were told was going to cost about 1.5 million, and that was a conservative estimate. This one will cost a little over 500,000 because we're only looking at children that are at risk at being removed from a home. It adds a new provision granting appointed counsel the right to view and copy the child's medical, psychological, education, and other records necessary for the counsel to provide competent legal representation. And records provided to counsel under this section shall only be used for proceedings under the Child Protection Act. So they're going to get access to all their records, and those records are protected. And I think that's very important when we're talking about children. It adds a new provision to the Foster Care Children's Bill of Rights requiring notice to the child of their right to appointed counsel. So the question is, why? Why do these children in these particular situations need attorneys? Well, first of all, they're legal parties to abuse and neglect cases. And the New Hampshire Child Protection Act and Foster Care Children's Bill of Rights provide children with many legal rights, which only legal counsel can ensure are protected. Children, again, face potential loss of their family, friends, belongings, and communities through no fault of their own. And I think that's important because these children are abused and neglected, and oftentimes they're made to feel that it's their fault. And it's not. It is not their fault. Children may be subjected to abuse or neglect in residential facilities, including possibly being subjected to prone restraint, which is now unlawful in New Hampshire, despite passing a law. The Children's Oversight Commission still receives complaints about children that are subjected to prone restraints. Children deserve to have their voices heard and respected, especially in matters that will significantly impact their lives. Having counsel to represent the child's expressed interest will empower the child in situations where they have little control and the stakes are incredibly high. Providing counsel for children placed in residential facilities or at risk of such placements will ensure that their rights are adequately protected. The attorneys appointed for children will provide legal advice and develop legal strategy. They'll represent the child's perspective and express the child's wishes to the court. Help the child understand their options and fully participate in legal proceedings, and ensure the child is treated fairly through the legal proceedings. Providing counsel for children in these cases is a nationally recognized best practice. Children who have legal representation obtain better results than those who do not, including less time in foster care or group settings, shorter time to reunification with their parents, adoption, or guardianship. We were told on Friday that currently there's a young boy who's, I believe, 11 years old, who has been in a group home for over 5 years. That's unacceptable, and we have to take care of that. And there are fewer school transitions. We in New Hampshire are an outlier. We fail to protect children's rights in ways that most other states do. New Hampshire is one of only 13 states that do not guarantee the right to counsel for all children throughout abuse and neglect proceedings. And I've got the list of, I don't know if you want me to tell them. No, okay. New Hampshire is only one of 6 states that does not guarantee the right to counsel for children in abuse and neglect proceedings under any circumstances. So, Mr. Chairman, at this point, I will conclude my testimony. I will try to answer questions, but as you can probably see, we have a room full of advocates here that really support this bill. So thank you all very much.
Thank you, Senator. Any questions to the senator, which she has the right to defer to the room full of? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Senator. My question is about where the attorneys are coming from. Is the state hiring attorneys for this purpose to be state employees, or are these people already out doing family law practice?
Thank you for the question. I'm going to defer that to the department. They're the ones that could answer that question much better than me.
Seeing no further questions, thank you so much for coming.
Thank you
And
very much for your time this morning, Mr. Chairman.
Chair recognizes Cassandra Sanchez and Attorney Lissa Macio from the Office of the Child Advocate. And you do know what Rule 1 in this committee is, don't you? Fulfilled. Turn the mic on. Yeah, thank you.
Good morning, Mr. Chairman. And thank you for allowing us to testify this morning. We are here in support of Senate Bill 463. As you heard prior to our testimony, Alyssa is going to pass out some written testimony as I start here. But as you heard from Senator Carson, as she was presenting the bill, our children in care do suffer quite a lot, and they do have advocates currently already through CASAs, but their expressed interest is not currently represented in the court case. They are currently the only parties in these cases that do not have legal representation, and those are our most vulnerable parties in all of this. So it is quite critical that we seek to add these protections for our children and advocacy in the court arena. To add to that, as she shared, we did have the experience of going to Bledsoe Youth Academy, but that is just one example of many where we see children lingering in residential care. So where this bill adds the protections, particularly for children either already placed in residential care or at risk of residential placement, it is critical that we help these children move along in their placement, in their treatment, and return to a community setting so they have an opportunity for better outcomes long term. Currently, you will see in the written testimony on the final page, we have an update of the data for children in placement as of the end of March. When we are talking about children currently in residential care that would be receiving attorneys, we are particularly looking, if you look at that top box, under CPS and lined with group care, there's 124 children that are involved in child protection that are in residential care. So we are not looking at an extremely large number. When we're looking at total children in care, we're looking at about 1,200 at a given time, but we're talking about around 120 children that would need this representation, just slightly above that number because we're also capturing children at risk. But we're not looking at a large number of children and a large number of attorneys needed, but we are looking at our higher needs children and those that do often linger for quite some time in care. Also to share, you'll see if you look down in the bottom right-hand corner, children outside of New England, as of the end of March, is totaling 7 children. As of the end of February, we were down to 2. So we've had quite an increase in just a month's period of time. Why is that happening? We hear a lot of different reasons why that's happening. Our facilities here are full or are unable to accept these children due to behaviors. They have potentially been in some of the programs in state, and those programs have not been successful for them, so they are being sent out of state for higher level treatment. But what we see when we see this number rise is we see children being pulled from their communities, from their core relationships, their schools, their families, and not having that consistent tie back to the life that they once knew once they leave our state or far away from our state. As you know, we've discussed in many other bills this session that we really would like to see as many of our children stay as close to home as possible and stay in these family-like settings. And it truly does take them being closer to home and having appropriate advocacy for those treatment episodes to be short-term, to truly address the problem and then return the children to their communities. And we do believe this bill is going to help this, along with other bills that have been before us this session. We do believe in conjunction, these bills will help move New Hampshire in the right direction to continue to reduce out-of-home placements for children and continue to reduce the length of time. As you heard from Senator Carson, Alyssa and I did have the experience of going to Pine Haven Boys Center and meeting with a young child there who had been in that program off and on for 5 years. That is far too long for one child to linger in care. Of course, there's a multitude of reasons as to why that happens, but we do believe that he needs adequate representation to be able to move along and end up in a family setting, and ideally sooner rather than later. When we have a child that's been in a program like that where they can enter as young as 5 or 6 years old and has been in that program for 5 years plus, now they're approaching their teenage years, and it's a lot harder to look to foster homes and adoptive homes to take in those children and provide level of permanency that they need.
And just anecdotally to add to that, the importance of attorneys, we've had several cases recently where children are ED boarding for upwards of a month, 2 months. In one particular case, the child was in the guardianship of the state, so there's not even a parent advocating necessarily. They were looking to send this child thousands of miles away to a newly certified out-of-state placement, but with some creative work with the division, that child is now successfully in a foster home. So again, there's lots of situations where having additional advocacy, in our office can do some, but again, we're an office of 8 people. Having an attorney, that attorney would be doing that work to say that that's not appropriate, that level of care is not appropriate, this child doesn't need to be thousands of miles away. So an attorney in a case would definitely add that layer of advocacy. In that case, unfortunately, that child also didn't have a CASA, because as we know, CASAs are also excellent advocates for children, but there are children in care who are beyond the normal reunification case that you don't even have CASAs sometimes. So I did just want to point out to you at the bottom of page 2 and on to 3, I know this committee doesn't often look at the fiscal pieces, but unfortunately, some of these bills, especially when read together, the fiscal notes are difficult to explain and fluctuating wildly. Senator Carson mentioned that HB 535 had a price tag of 1.5 million, but somehow HB 463 has a price tag of 500,000. They are the exact same bill other than the finding of facts, exact same number of positions and types of positions. So we do worry that the number of positions being requested, the types and levels of positions being requested, particularly when you look at all 3 of the bills you're looking at today in concert, which also I know House Finance will do, just to look closely at that. I know that you all are also concerned about the finances, even though you're a policy committee. So we did just include a little bit of information there on the bottom of page 2 and on to 3 for you guys to consider.
We are open to questions.
This bill takes effect in 14 months plus, July 1st, 2025.
Correct.
As of that date, how many more lawyers will there need to be, in your opinion?
Currently, there are already parent attorneys that Judicial Council assigns. So there is already a pool of attorneys who represent opposite DCYF. I myself was a parent side attorney for about 4 years earlier in my career. We would presume that some of those attorneys would also represent children. Some of them are also GALs, so they do kind of float between cases. In addition, that gives the judiciary time to do outreach and do training. Already just this past year, there was a training offered by the courts in conjunction with a national attorneys organization that did parent attorneys, and there was dozens of attorneys that showed up to that training, including many first-time attorneys wanting to represent parents. So it'd be a similar pool. As we said, there's only 124 children. So typically, a caseload, they're handling multiple attorneys. I know when I was a parent attorney, I may have 5 or 6 cases on my caseload in addition to my private practice. There are some attorneys that this is all they do. Their entire caseload is these contract-based attorneys. So I couldn't give you an exact number, but 124 kids would not necessarily be that many more attorneys. And Also, the Judicial Council is currently working, I believe it was heard last week in front of their board on standards for children's attorneys, which I think some other folks here can speak more to. So the judiciary is already getting ready for this to happen, but they need this bill to pass in order to make it happen. But they're laying the groundwork, and there's definitely attorneys out there that want to do this type of work and are already doing similar DCYF related work.
Thank you. Any further questions? Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. So my question is about the effective date. So this would take effect July 1st, 2025. Those 120-ish kids, would they automatically qualify to get attorneys, or would it only be children entering group homes after that point?
It would be children in care at that time frame. It hopefully would be a different pool of children in that time frame because they should be moved on elsewhere and not linger in care for a length of time. But it would include all of the children that are already in group home care, and then any that are in that at-risk category.
Okay, thank you.
Representative McMahon.
Thank you, Mr. Chairman. The question to either one of the professionals here, in page 1 of the bill, where it states the court shall appoint a CASA representative, or if it's not available, they may then appoint an attorney. And then though in section 2, there's a new addition where again, it says it may appoint if a child requests the appointment. Does that indicate an out where nothing happens? And an out meaning for the authority having jurisdiction to do something for the case that's in front of them. And that's in that wording in page 1, line 22. You'll see in that paragraph, and then page 2, the starting in line 5, it's where the new in black wording was put in, and has this may appoint versus shall.
So I believe the language you're pointing to is current law. Currently, the court is required to appoint a CASA. If there's not a CASA available, either because they don't have enough or there's some sort of conflict, there is also a pool of private guardian ad litems, some of whom are attorneys. So that's why that's worded that way, because financially, the state doesn't pay CASAs, they're volunteers. So that's why that's the first choice, is this volunteer CASA program, which a majority of children do get. If there's an issue, though, that's where it then flips over to they do need a guardian ad litem. It might be an attorney, or it might be a certified guardian ad litem. And I know we've talked in this body before about the guardian ad litem board. So it's just different groups of people playing that same role. So that's really kind of current law. The new law is exactly where you pointed, where now that second paragraph, the court already has discretion to appoint an attorney to children, but it's very limited in current law. It's only at the dispositional hearing, which is very early in the case. And it's only if there's a conflict between CASA and what the child is saying. This just broadens that discretion to the judge, that they could appoint a children's attorney at any point during the case, not at that one moment of the dispositional hearing. And it's a little bit broader in that there doesn't necessarily have to be a conflict that the CASA's saying. It could just be the child expressing. And again, that's totally at the judge's discretion. Currently, and presumably even under this, it'd be something pretty serious, not like, hey, I don't like the cereal my foster parents give me. It'd be something serious. That new whole section, Roman 2B, that's the new law where the court shall appoint an attorney to any child in residential care currently, as Representative Raymond asked. And then there's these trigger points that if the child is at essentially imminent risk of being placed, and there's a couple trigger points that we know of when they're sending out a CAT evaluation, which is sort of what gives you placement levels. When they're sending out packets to placements, that's how a kid gets placed, is you send a little packet about the kid to Nashua Children's Home, to Wadiko, so those are the trigger points that DCYF knows we're now actively looking for residential placement. They then need to tell the court we're actively looking for residential placement, and then the court would appoint an attorney in the hopes that, in fact, maybe not all those kids end up in placement, is the hope.
One follow-up, Mr. Chairman.
Follow up.
didn't address you correctly, attorney, so sorry about that.
You're welcome to. Correct me
The,
anytime.
Well, again, relative to this is so that a child is not left alone when in these two cases, in the narrative that's in and the reference to expressed interest of the child is when I see the words may, it's leaving things in abeyance for maybe a long time unless you're present in the court to see what's going down and what isn't. Is this wording appropriate enough to ensure that the child that does express a self-representation interest for an attorney, that this would be answered by the judge, irrespective of the fact there's not a CASA available, but that an attorney would be so appointed?
So the CASA is always going to get appointed. There's no change to the current law where CASA is appointed. The language in that first section is still filling that CASA role, that best interest role. It's just when a CASA isn't available, which is not terribly often, that attorney is a GAL attorney. It's not a representation attorney. Just some attorneys are trained as GALs as well. So like I said, that pool of parent attorneys, they do fluctuate. Some of them are trained as GALs, so you may see the same attorney show up in a case as a parent attorney, in the next case they're a GAL. It's that next two paragraphs that are appointing attorneys to represent that child's interests, not that best interest role.
Is the primary difference here, then, just one final clarification, is whether the subject is to be placed in a group home or out of state, as opposed to handling the issue in-house, in like where they currently live?
Yes. So the first paragraph is not related to residential placement. It's just an expressed interest of the child that is, needing attention. The second paragraph is the mandatory one, where if a child is in residential placement, that could be in-state or out-of-state, a group home, a treatment facility, they are going to get attorneys under this law.
Okay, thank
And
you very
that's
much.
those 124 kids that we're talking about.
Understood. Thank you, attorney.
Representative Nelson.
Thank you, Mr. Chairman. Thank you for being here and for taking my question. This is specific to children who are nonverbal or who have limited verbal ability and communication skills. How do we determine for these types of children, how would we know that they would want to request representation? And how would the expressed interest of a child be represented? Thank you.
Yes, thank you for your question. So first and foremost, that is the critical piece of ensuring that it is in the Bill of Rights for children, because then it has to be explained to them. And if it is a nonverbal child who's at a program, it is the DCYF staff that would sit down and explain the Children's Bill of Rights, but they should be sitting down with the staff who works at that facility, who knows the child well. When children are nonverbal, it doesn't mean that they can't tell us what they're thinking or feeling. It's about the skill in the person eliciting the information to be able to get that from the child. And so they should be working with the staff. A lot of the programs that have children that are nonverbal have either 1-to-1 or 2-to-1, very small ratios. And so there would be staff that were quite familiar with the child and could pick up on their cues and know that they maybe having that interest and and are trying to express that. So they would be part of that conversation. It would require that specialization. And then, as Lissa had mentioned, they're talking about standards for counsel for children, but that is that next level specialty for when that attorney becomes that representative for that child. They also need to understand the nuances of working with that child, and they should be working very closely with other members of their team, with trusted staff, with it could be guardians or other adults in that child's life that know them very well. And so they are entering part of that team. And the hope is that they're working together, much like with CASA. They also have to do the same when they're working in representing the best interests of these children. They have to get to know where they are, who they work with, who they trust. And so they should be an added member of that team. And they should be working very closely with CASA and understanding what they're representing for that child.
Thank you. I really appreciate that answer. Thank you.
Representative Ball.
Morning. Thank you for being here and taking my question.
You're welcome.
Sorry. Thank you, Chairman Pearson. I feel like we've had so many weeks off, forgotten my protocol. Thank you as well for being here. In comparing the House Bill 535 to this one, I'm only seeing a difference of in line 17 and line 18. Am I correct?
I do not have 535 with me currently, but I do understand one of the other differences between 535 and 463 is in the statement of findings, where it speaks a bit more to the important role of CASA and how they would continue to be a part of this process. I believe it's just that one. Is this one 10? So it's
Somewhere else you're pointing to?
page 2, line 10 through
looking-
14.
I'm looking at page 2, line 17 and 18. After it said RSA 170, it says or certified by the department, and then to the end of that sentence. That appears to be new. So that would be, that appears to be the only difference between.
Yes, thank you for pointing that out. That is a new line. It just clarifies to ensure that we are capturing all facilities under, because the RSA 170E is in regards to licensing, and that's the focus of that statute, where there are facilities that are not licensed by the state of New Hampshire because they're outside of the state of New Hampshire, but they are certified by the department. So that would capture all of those out-of-state facilities. So that additional line ensures it. Yes, it ensures that it is covering all of those placements that are certified for placement of children in 169C cases, which are the child protection cases.
Follow-up, Chairman?
Follow up.
So in going back to House Bill 535, I believe we had passed that 15-1. And so really all we're looking at now is just adding those two lines to the
Yes.
Senate bill. Thank you for that clarification.
Yes, thank you.
And 535 was heard a few weeks ago in Senate Judiciary as well.
Any further questions? Vice Chairman Long.
Thank you, Mr. Chairman, and thank you for your testimony. I've for 2 or 3 years now, I've had this thoughts about, as you testified to, the 11-year-old being in the system for 5 to 6 years, and also youth that age out. What happens after they age out? So when looking at line 15 on page 1, it appears that my concerns with that is going to be addressed with this expressed interest of the child attorney. So in your opinion, do you feel that they would be more looking, not only looking for permanency, but looking for if they age out, or the longevity that they've been in the system, and why aren't they placed in permanency?
I mean, I think the examples we were talking about, those children were or had been in residential care. So they would actually get attorneys, the mandatory attorneys, under the next section, which I think is even more important. The expressed interest piece is still at the discretion of the judge. So there certainly could be particularly older teens that you're referring to that are expressing an interest maybe at odds with what their CASA is saying, that may fall under that first expressed discretionary piece, but most of the kids I think you're referring to have been in residential care or will end up in residential care at some point, so would get those mandatory attorneys.
Okay.
And yes, we do believe that they would be looking out for permanency, ensuring that there is a plan, ensuring that the child's voice is part of that plan, which is truly critical when looking at that section there. And they're talking about the outcomes and reduction of time to permanency. It is critical that the child have buy-in, particularly if they're an older child, for what their plan is going to be. We see many times that a goal may be adoption for an older child, but they do not wish to be adopted. And so those are the children that will linger because they will not agree to that final permanency plan. And so having an attorney that's going to be advocating for what they want can lead to an opportunity for alternative permanency that's going to work for the child, they're going to buy into, and they're going to put their efforts to make it work.
Okay, and a follow-up, if I may, on
Follow-up.
on line 16, children who have legal representation feel a sense of agency. Should it be a sense of urgency? It is agency?
Agency, yes, because then their voice is truly heard in the process through their representation.
Okay, great, thank you.
Maybe urgency as well, but we did mean
Right,
urgency.
okay.
Representative Panic.
Thank you, Mr. Chairman, for allowing me to ask a question, and thank you for coming in. I have one question. If a child is already in placement in like a foster care somewhere, and there's abuse going on, and the child wants to complain, I'm not talking about soggy oatmeal. I'm talking about real abuse going on. This would take care of that situation as far
So
as,
those children would not be assigned because when we're speaking about in placement, we're talking particularly about group placements or residential facility placements, but it would allow the changes to that first section on page 2 that we're talking about. So lines 6 through 8 on page 2. Or sorry, I may start prior than that. That allows a child to request. So if a child is in that situation, they're advocating for themselves to those around them and they're not being heard. It does allow them to ask to have representation in the court. The court does get to make the final determination whether they're going to, but previously they could only ask at the disposition. As Attorney Massio was explaining, at this point, if the disposition has passed and the abuse is happening, they have an opportunity to still ask the court for representation. And those are those serious situations where we hope the court would take that discretion very seriously and understand that there is a clear reason for that child's safety to have further representation.
There is, though, also a process internally. There's a special investigations unit within DCYF that investigates those sorts of allegations within foster homes or group homes as well.
thank you.
Representative Bickford.
Thank you, Mr. Chairman. And thank you for taking my question. You have pointed out on your handout on page, I think it's second page, and, no, it's next to the last. At the top, you're talking about 124 children. I've heard you mention that numerous times. But isn't that an in-camera look at the outstanding? The way it reads anyway, it says, that's how many we have outstanding in March, it looks like. Couldn't this be a rolling number and actually over the course of a year be much higher?
It could. Children enter and exit care at different times. So the data that we have at hand before us is not easy to separate out. And this is unfortunate because we've tried to gather this data, but the way in which the system works is not easy to separate out how many of those placements for children in residential care are first-time placements, because we also have children who may have been in residential care, attempted to transition to another placement, returned back to residential care. So those numbers are shifting so regularly that it is hard to track. And the way that the current data system works within DCYF, it doesn't allow to pull very clean data in that way. You could do that for all children in placement, but you cannot separate out specifically children in first-time placement in residential care. But at the same time, there's also the children that will transition out of that care for reunification, which should be occurring in a year time frame. So yes, this is a point in time glimpse of 124, but from 1 month to the next, that could be the same children, and it may take 6 months for new children to enter and end up in residential care. There's no way to get that clear-cut number. So we are pointing to 124, but recognizing that it is going to be higher than that number.
But also that number has stayed pretty consistent. We started working on this bill with this committee last summer, and consistently month over month, that number has hovered between 115 and 125 every month.
Okay, thank you.
May I, while we're right on that page and line, top of line 3 of the handout, there were 124 children, so that would be 124 attorneys. That is assuming a one-on-one. That's what you have written here. What you mean to say, I think, is there would be 124 attorney assignments.
Correct. Yes. As I stated before, usually an attorney's carrying a caseload of, half a dozen to a dozen or more of those cases.
So we should understand the second line in that light.
Yes. Thank you for catching that. Yes, that is assignments.
You
It's
people are
not that there
training me
are
to think
attorneys.
like a lawyer, you know that.
But it's not an annual number, that's my concern.
Yeah.
It's only to March.
Any other questions? Seeing none, thank you very much.
Thank you.
And the chair recognizes Karen Rosenberg from the Disability Rights Center of New Hampshire. And a blessed Hanukkah to you.
With all due respect, it's Passover.
I mean Passover.
I know you did.
Thank you.
Yeah, you were.
Yeah, you weren't
it's the
going to
cold
pass over
weather.
that era
It was the
either,
cold
yeah.
weather that was throwing you, but yeah, it's Passover.
A blessed Passover. I know the story. I've seen the movie. Yeah, thank you.
Thank you. Good morning, Chairman Pearson and all the committee members here. I'm Karen Rosenberg. I am the Policy Director at the Disability Rights Center, the state's protection and advocacy system for people with disabilities, here in strong support of this bill. And Disability Rights Center is also a member of the Juvenile Reform Policy Group, which is also in support of this bill. And our member agencies are New Futures, Waypoint, the Children's Law Center of New Hampshire, and New Hampshire Legal Assistance. So, and I forgot, I actually have written testimony. Well, I have some support fee that I will hand out on behalf of the Juvenile Reform Policy Group. So first of all, I actually really want to thank you all for the commitment and work that you have done on this really important issue for children in our foster care system. I mean, you have started working on this over a year ago, right? You had HB 535, you met, you did a substantial overhaul, really zeroing in on making sure that the state will provide counsel for children in limited circumstances. We're talking about a fraction of children who are in the child protection system, but those are the children whose rights are they're in grave circumstances. These are
Statements of lavish praise will be limited to 10 minutes. Just saying.
Well, you all deserve it, right? You worked hard. You had, you ordered us to work together. You considered testimony from a lot of stakeholders in this area, and we're really thoughtful in amending 535 and ushering it to its ultimate passage in the House. So I think this is just really important recognition. So 463 is a bit different, but not a whole lot different. And I think that, we had members of I'm going to call it the JRPG, okay, the Juvenile Reform Policy Group. We had some more time to reflect on what we were hoping to accomplish. And that is why, for example, the description of the facilities, how we refer to what facilities would be considered those residential group facilities, is slightly different in the bill that's in front of you. Because what we realized is that although all of us intended to provide counsel for children who are in group and institutional placements, that limiting the description to only those in E25, I should pull up the actual statute, it inadvertently omitted, for example, like Hampstead's hospitals residential treatment program, or it inadvertently eliminated programs that are out of state where they may be certified and not licensed. So we have a little bit more time to perfect this a bit more. So that's a difference here. Another difference is that, as I think Cassandra or Lissa may have mentioned from the Office of the Child Advocate, this bill really recognizes the strong collaboration that children, the courts, and that these parent attorneys will have with CASA, because CASA is really important in these cases. They're weighing in on the best interests of the child in the opinion of their volunteers. They are forming lasting relationships with some of these children, and so we felt it was important to recognize that. One other thing that happened as this bill made its way through the Senate, and wait, I forgot one other thing. I wanted to thank Chairman Pearson and Representative Ball for co-sponsoring this bill, because that's another important thing to note. Because you, unlike the rest of this committee, you had an opportunity to look at the revisions that were, between the two bills. So what happened as it went through this process is that there was an appropriation that was added to it for the next fiscal year that was in recognition of some staff members that the department felt that they really needed to add to effectuate the bill. And then it also postponed the effective date of this bill. So in HB 535 and in the original version of this, the bill would have been effective January of 2025. So this postpones the effective date to July, more than a year from now. And I think that in doing so, it does two things. Perhaps in these times when we're still trying to get a handle on the budget, it allows some more time for that, but it also allows much more time to gear up to recruit and train the attorneys who will be representing these children. And to your question about how many attorneys, it's hard to predict exactly, but when you look at like a full-time equivalent, I don't think many attorneys will be taking these cases on as their full-time and only job. But a full-time attorney, depending on the kinds of cases they have, could easily have 25, 40 cases that they're handling at any given time. We know that unfortunately our public defenders handle at least twice that many cases. So if you even kind of bid high and think about, well, maybe this number goes up to 160, that's 4 FTEs. It's not a lot of attorneys that we need to do this, but we will have some time, and you've got some really invested stakeholders here. You'll hear from one who is ready and willing and able to start doing some training. And then you've got a commitment from my organization and others to do our best to come up with some creative ways to recruit attorneys. We think these are cases that attorneys are going to want to do. So I think that's, I'm happy to answer questions you might have. If you want more information, but honestly, I think that either one of these bills would be a huge step forward for some children who are in the court system through no fault of their own, but who are in really dire circumstances and are at risk of really having a very fundamental right, like where they live, who they associate with, where they go to school, taken away from them. So thank you so much for your consideration.
And are there any questions? Seeing none, earlier you referred to anticipation. Please find my Hanukkah comment under anticipatory and let me be the very first to wish you.
Oh my gosh, thank you so much. I will note that you were the first person to wish me happy Hanukkah.
Chair recognizes Attorney John Williams from DHHS.
Good morning, Chairman Pearson, members of the Children and Family Law Committee. For the record, my name is John Williams. I'm the Director of Legislative Affairs for the New Hampshire Department of Health and Human Services, and it's in that capacity that I'm here before this committee today. Although the department is not taking a position on the bill, clearly we are a very interested stakeholder in this very important venture, and you've already done a really good job walking through the bill to do the crosswalk between Senate Bill 463 and that involving HB 535. Essentially, this adds in Section 1 a new purpose and intent section. You clearly identified that the change that you saw on page 2 on lines 16 and 17 relative to certified facilities were added. That's very minimal changes from the bill as you pass out of this committee. Additionally, and it's important to note, and I just wanted to put a couple of things on the record for some level of clarity, it is true that the effective dates for both of the bills is July 1st, 2025. That means that whatever is being done here in terms of necessary resources for the department, and also I understand the judicial branch also is here and may provide some level of commentary, that there is an opportunity as part of the 26-27 budget to build in those necessary resources. When we were before the Senate committee, they heard our voice and they acknowledged our concerns regarding the need for staffing, including 5 attorney positions and then a designated number of the positions for CPSWs, otherwise known as the Child Protective Service Workers. There was one thing that I do want to make note of on page 3 of the bill, as I'm referencing your attention to Section 3. That Section 3 is identical to the provisions that amends the Children's Bill of Rights, and I just need to go on the record very clearly stating that this is a very careful balancing act that must occur. It is very important for these children to receive the information as to the access to counsel and the right to do so, but very carefully balanced against representational capacity. The attorneys for the Department of Health and Human Services represent the department. They do not represent the individual interest of the children in these matters. So the way it's currently worded, and I just want to bring your attention to page 3 in line 6, it talks about written statement of these rights and the process in which to request an attorney. Very clearly, if the department's role is to provide that information, we believe we're threading that needle very carefully not to cross the bridge between representing the department and representing the interests of the child. It is very good that this legislation is effective on July 1st of 2025 because it does allow us to work with the stakeholders on perhaps further refinement of this section. It's our interpretation going on the record that this would not be a breach of that representational capacity and that we're just merely providing per the law the written statement of that right and some level of written direction on how they could access it. Great questions were asked, I believe, of Representative Nelson, in getting into the weeds a bit in terms of how do you address it with children who might have communication needs that require some level. Those are additional issues that will need to be worked out moving forward because the current legislation just provides the department's requirement is to provide a written statement and also an explanation of that process. It doesn't require any other level of communication. I would represent to the committee, though, our department takes making very important the need for communication. And in fact, we have a complete communication protocol for individuals who English may be not their first primary language, individuals who may have either hearing impairment issues, as well as those who may be nonverbal, as was discussed by Representative Nelson. So I just wanted to go on the record really, really clear on behalf of the department and our representation through the Department of Justice that we do not see this specific language as us breaching our representational capacity in providing that information. And we need to say that because others might have a very different opinion in terms of our participation in the process. The other piece is in Section 4, and it was alluded to in Attorney Macio's commentary, that there is a disparity between the fiscal analysis on this bill, Senate Bill 463, and that done on House Bill 535. The first thing I just want to bring on this issue around the fiscal impact is if you look at the actual fiscal note on the back of the bill after you get past the effective date, you'll notice that the fiscal analysis on this bill was done on the bill as introduced. It was done on January 24th. So this is a very, very outdated fiscal analysis on the bill to begin with. I was in direct communication with Mr. Kevin Ripple. He is the LBA analyst, and he actually was hoping to have it turned around by today. I was checking literally seconds before coming up and testifying. It has not been updated, but he is going to provide an updated fiscal analysis. The $500,000 or the $508,000 represented in the appropriation in Section 4 actually represents the general fund portion. There is a federal match that comes with it to help offset the cost, but the general fund portion for just the attorneys, it does not represent the cost that it would be required for the 14 child protective service workers. If you take them into account, you then come in complete alignment, and you'll see that it is anticipated that you'll see Mr. Ripple through the LPA will demonstrate that the cost will be approximately $1.5 million general funds, whether you're going through HB 535 or through this bill. I only went into that level of detail because it was mentioned in a previous comment before this committee, and I just wanted to clarify that information. And with that, in taking a deep breath, that concludes my testimony, and I am available to take questions on behalf of the department.
Representative Bickford.
Thank you, Mr. Chairman. Thank you, Attorney Williams, for coming. I've been waiting for you. You got 5 staff attorneys here, 2, and I'm not familiar with grades. But how many do you have now? Why is 5 the right number?
I would need to get back to you on the exact number of current attorneys that we have, but I would be very clear to say that I'm sure we have quite a few more than 5 attorneys for our current workload. The reason why we need the additional 5 attorneys is because the bill does require something different. And as Representative Ball pointed out on that additional language here, and also Representative McMahon, the may, which is under current law in terms of the best interest of the child and the court being able to do that, there's now a shall relative to the specific placement of a child in the settings that are identified in the legislation. And because of that, and attorneys are wonderful. They are absolutely wonderful in terms of the representation. But if you do have an attorney appointed to representing a child, there is anticipated fairly that there's going to be additional work on the department side to address the legal concerns that are going to be raised by the child's attorney. In addition to that, there'll have to be investigations and also additional information provided, and therefore we need the additional workload for supporting child protective service workers as well. And that's where the department's financial analysis comes. The Senate heard this, and they agreed and provided us with an appropriation, at least for the attorney positions, and that was the $500,000 reflected here. That's not the total amount, and it was the department's failure to identify that additional amount on the prior amendment.
Follow up.
Thank you, Mr. Chairman. So it sounds like you're doubling the attorney staff?
Oh, nowhere near that. I will get back to the committee with the exact number for staff, but it's nowhere near doubling the staff that we
Okay,
have.
I'd be curious to know more about the organization. And one other thing, based on the information we got from the child advocate of 124, that was an in-camera look. It said, as of March, bingo, this is what we got. But I would think the numbers would change. One would be taken care of, then another one comes in, and then another one. It could be much higher than that at the end of the year. Do you have any idea how much it would be in the course of a year?
I do not, but part of our analysis and the folks that did work on this, and I was part of at least the overview of reviewing the fiscal analysis from the department to the LBA, that these are rolling numbers that you're referring to for the department, but I believe that the numbers represented by the Office of Child Advocate were the same numbers that we'd expect.
Okay, thank you.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. Piggybacking off of Representative Bickford's questions, if the numbers in this fiscal note are based on DCYF staff, additional staff, then where is the money coming from to pay these child attorneys, right? If it's not coming out of the DCYF appropriation, so where is that coming from? I just want to be clear that we're not going to be charging parents for the attorneys that the children need.
And Representative Pearson, sometimes when I'm sitting in the gallery, I actually feel a gravitational pull when questions are asked of the department, and I know I'm the right person to come up. The question that you're posing actually involves the judicial branch. I do know a member of their general counsel is available. I don't know if a pink card was submitted, but they could certainly explain to you how that would be funded through the judicial council. There is a funding process. Also, the department recognizes in the very good works of this legislature here, the works in the Senate, that we actually worked in the past to remove what they called parental liability. In the past, we would charge the parents a portion of the amount of money for the treatments that the children would receive, and nowhere in this legislation is it contemplated that the parents would be responsible for having to repay the attorney's fees for those attorneys that would be appointed. Therefore, those would be a cost to the state, and I would leave it to the judicial branch to respond to those questions.
Thank you.
Seeing no further questions, thank you very much.
And thank you very much.
And we're running a little bit over, and we have 2 pink cards, so I would ask the last 2 people to be brief, please. Chair recognizes Lisa Wolford from the Children's Law Center.
Thank you, Mr. Chairman. I also have written testimony. May I distribute that quickly?
Yes.
Good morning. My name is Lisa Wolford. I am a lawyer and the executive director of the Children's Law Center of New Hampshire. We are a legal services nonprofit dedicated to the legal interests of children, and we do the work that SB 463 contemplates we represent children in abuse and neglect proceedings under RSA 169C, the Child Protection Act. I've provided written testimony that describes the many legal rights that the legislature has afforded children in 169C cases, and I want to just focus on 3 points during my testimony this morning. The first is that the state of New Hampshire over-relies on institutional placement for children, despite evidence indicating that institutional placement produces bad outcomes for kids and therefore also for society, and despite the exorbitant cost of institutional placement. That about 26% of children in state care are placed by DHHS and our courts in institutions, and that is one of the worst, if not the worst, records on institutional placement in the country. Children's legal rights are currently all but invisible in 169C proceedings, and lawyers for kids will make a difference. To focus just for a moment on the types of advocacy lawyers can provide for children, with regard to institutionalization for kids at high risk of institutional placement, lawyers will advocate that the child and his or her family have access to community-based counseling, mentorship, and in-home services, that respite care is available if necessary, that adult mentorship for the child is available, that DCYF complies with the Foster Care Children's Bill of Rights, that the toxic effects of poverty are offset by available federal, state, and community financial assistance, that prior to placement at an institution, DCYF, the child's school district, and the court comply with the law concerning the due diligence that must be engaged in regarding the child's access to special education. Most of these children have special education needs, and frequently when they are placed in institutions, we see that they are not afforded what federal and state law entitles them.
You have 1.5 minutes to conclude, please.
Okay. The last point I will make is that the Children's Law Center has begun to implement a plan to train lawyers and assist in the process of recruiting them. You heard earlier that the Judicial Council was working on standards for the representation of children. I was involved in that effort. Michelle Wongren at New Hampshire Legal Assistance was also involved in that effort. And the Judicial Council on Friday adopted standards relative to the representation of kids in 169C cases. We have done quite a lot of outreach to law firms. We know that lawyers in private practice are interested in these cases and in fact have recruited pro bono lawyers to do the work that we do and to work with us on those things. I will work with the Judicial Council and other interested stakeholders to provide trainings for these lawyers, and I have faith that the judicial branch will also collaborate with us, despite their reservations, over the next year in ensuring that there is an ample supply of attorneys who are trained to represent kids in these cases.
Any questions? Seeing none, thank you.
Thank you, sir.
And the chair very much, and most chairs very much appreciate when people who wish to testify send in their pink cards well in advance and not at the last minute. The chair recognizes Michelle Wongren for 2 minutes. 2 minutes.
Good morning, Honorable Chair and members of the committee. This is my daughter, Sarah Wongren, who's
She's
here on
having a
school vacation.
wonderful calming effect on the audience. They're usually not very well behaved, so thank you for modeling.
She is wonderful. You should see her notes that she's been taking about the importance of legislative work. I am impressed. But I am here to testify in strong support of SB 463. We think that this is an incredibly important right for children, and I think it needs to be recognized as such. When children are in abuse and neglect cases and at risk of institutional placement, not only are they at risk of losing their familial association, but they're also even more at risk than I would say their parents are, because they're also at risk of loss of liberty if they go to institutional placement. And so I think it's incredibly important to recognize that if this right is established, it needs to be a right that means something and that truly does enable them to access counsel when that counsel is needed. I just wanted to make a couple of points on the amended fiscal note that I think is coming down the pike. For one, the fiscal note in this case indicates that the department would need 5 attorneys to do this work. I share the concern that 5 attorneys seems like a lot for the department to need when it's unclear if that's even the number that children will need for this representation. It very well could be, but it's important to recognize that the department's attorneys are already providing representation to the department, making sure that the department is following the procedures and the policies that are established for them, arguing that they are following the policies that are established to make sure that children are only removed when they need to be removed, that children are already placed in placements that are the least restrictive available to them. Sure, there will be some additional legal arguments, but those legal arguments will most likely be made when the department is not following its established policies to make sure that the children are in institutional placements.
Half a minute.
Okay, half a minute. Second, the new request for 12 CPSWs, I think that was something that was brought in the Senate as well. And Attorney Larrabee testified at the time that that need was to inform the children of their rights and to inform them of the process for doing so. I fail to see, when there is already a Children's Bill of Rights that that provides them a litany of rights that must be read to them and the process for exercising those rights, how this one additional right amounts to 12 new CPSWs at a cost to the state of $1 million. And I know we're not in fiscal, but I do think it's important to recognize that and to ask the questions of the department that if this is the fiscal note they're telling you exists, to bring in the people to explain what this extra additional work really does entail.
Thank you
that
so
this
much.
bill
Do we
does-
have any questions? You packed a lot.
I apologize.
She did a good job. So did you. Thank you. Thank you very much.
Thank you.
Chair now recognizes as our final speaker on this Attorney Erin Cregan from the Judicial Branch.
Good morning, Mr. Chair, members of the committee. Nice to see you all again. I always feel as though I'm the least exciting speaker because the judicial branch doesn't have a policy objective. We defer to you. We take your cue on policy.
Thank you.
When I review a bill that you've passed through each house in a substantially similar form, the thing that we're looking at it for is, do we have any questions on implementation? Is there going to be any challenge in implementing the will of the legislature? And I think for this one, there was a small challenge that we identified, which I believe can be solved. But we do have, in general, a shortage of attorneys of all kinds in New Hampshire. We have police prosecutors, we have paraprofessionals that represent people, but we also have a shortage of attorneys in this specific area that are knowledgeable. And there have been some family law judges that have sort of raised for me the question of what would we do if we had a mandatory appointment and we did not have an attorney available? We want to make sure that we're doing what you are envisioning that we would do in that scenario, not having different judges do different things or being confused about what the legislature's policy intention is. It could certainly be an option to say that the court should simply proceed if a person's not available, but you may determine that there'd be another answer to that question. It is certainly something that I hope does not happen, in which case if the language is added, it will never be used and it would not be harmful to add, but it is something that we would appreciate the legislature's guidance. There is another organization, the Judicial Council, which pays for attorneys in cases of criminal indigency, for parents who have proceedings brought against them. They've put a fiscal note, I think, on both 535 and on this bill. That's a little bit different, maybe from different phases, different versions of the bill, but they will have some costs. I don't think they've completely estimated what they are, but it's certainly in the hundreds of thousands, I should think. Unfortunately, Jay Bucky's not here. He was here at some of your hearings on 535, but that is a cost that you additionally would have to be paid for attorneys to represent the children, as opposed to the attorneys who are representing DHHS, who are provided for in the current language.
Thank you very much. And for the committee to know, we will exec this bill at 2:30-ish this afternoon. That is what has been noticed in the calendar. I have gotten OLS to prepare an amendment that moves shall to, we really hope we can, by taking out appropriate clauses of the bill. After an initial discussion amongst the committee, I may put the amendment into play or not, but I have it in case we need it. We may not need it, we may not wish it, but it will be there just in case, to speak to your point.
Thank you, sir.
Thank you. I guess so. Representative Bickford.
Thank you, Mr. Chair.
You're welcome.
Thank you, of course. You spoke of the Judicial Council. I'm thinking back, and it was my understanding a long time ago that Judicial Council would pay funds for parents that didn't have the money at the time, but there was an expectation for them to pay it back, and I'm not sure what the contractual side of that is. And do you know anything about that?
I know a little bit about it. I think there are many people who are not in a position to pay it back at any time in the near future, but they receive the representation notwithstanding and the Judicial Council does front those costs.
So,
follow up.
Thank you, Mr. Chairman. So at least there's an expectation that the parents would pay for it, isn't there? They wouldn't be absolved of not paying for their children, even if their rights are being removed, perhaps. Does that sound correct?
If I'm understanding your question correctly, and I may not be, I think you may be asking whether the parents would pay for this attorney for the child in the case of a mandatory appointment, and I don't see that is specifically clued to in this legislation or in any existing law.
Again,
Mr. Chairman, I think we should know that. We should know where the responsibility is going to be dropped, whether it's the state or whether it's the parents or sometimes the parents. So, thank you. I appreciate hearing more.
anything further? Yes, Vice Chairman Long.
Thank you, Mr. Chairman. So I think collaboration with the Children Law Center, saying that they will take on a responsibility of training attorneys would probably be good for the judicial to assert that with them. And also, if I may, with respect to the parents paying, I believe we passed there's a statute where for services, we don't charge the parents. And this would be a service, so we wouldn't be charging the parents.
Thank you. We will certainly collaborate. I think the Judicial Council has already started working, but if this will be a pro bono assignment, the mandatory appointments of attorneys, let's say a pro bono attorney takes 3 cases a year, you would need to have over 40 new attorneys significantly committing to pro bono that aren't currently being utilized somewhere else. That would represent a very big find that we would all have to run down, and that would be a challenge to do.
This concludes the hearing on Senate Bill 463. Thank you very much, Counselor, and we will be execing that later this afternoon. We'll take about a 1-minute break, and anyone who wishes to testify on Senate Bill 459, including the prime sponsor, please fill out a pink card. Right here. Usually that will go to the end and not approach the chair, please. It's okay. And while we're on our minute break, I have several copies of a model process for Family Justice Initiative pathways and a nice big thick 50 state statutory surveys on domestic violence. If anybody on the committee is interested in either one of these documents, come on up because I've got a few of them left. Which one? Okay. Okay, one set to Representative McMahon, and then if you want to wander with these. Very good. You're welcome. The chair has a question for Mr. Joe Burke from Security as to the score of the Bruins game last night. That bad? Okay.
Said that. Hockey is forever. Yes, it is. It never ends. The minute you go, it's over. Oh my God. I have two grandkids, as you know, that play. Oh, and the minute I think I have a weekend off, oh my God. And you gotta be there.
Yeah, yeah.
I think it's Southwest.
Taco
I don't have time. The only thing I can watch is. Yeah. But that really was. Really? It's on. Yeah. You should go. It is. I get it. Yeah, it's not very about it.
And Senator Carson, prime sponsor with an illustrious cast of co-sponsors, establishing a committee to study the Child Protection Act. You can start for the clerk. Okay.
Good morning again, Mr. Chairman, and good morning to the committee again. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 459, which seeks to establish a committee to study the Child Protection Act. Mr. Chairman, this bill didn't start out being a study committee. It was pretty much a complete rewrite of the Child Protection Act. As you can imagine, that is fairly extensive. And we did get some pushback concerning some of the definitions that we were trying to put into place. And as you can see, there were a number of child bills that came out of the Senate this year, and we just didn't have the time to go through this the way that it really needed to be gone through. So because it was my bill, I made the decision to put it into a study committee and work with the public to flesh this out in an appropriate manner. And hopefully next year, or the end of this year, we will all be sitting here again, and we can deal with this issue in a bill. And Mr. Chairman, just note for the record that whenever I suggest a study committee, I volunteer to work on it. So I'm not pushing the work off to other people.
And Senator, the follow-up statement by the Speaker of the House, negative towards study committees, was, Mark, you take care of it. So I'm quite happy to work with you about rounding out the committee for recommendation purposes.
Mr. Chairman, I love working with you.
Thank you,
So I
same here.
look forward to doing that. So are there any questions? Thank you very much for your time this morning, Mr. Chairman, and for all of your attention this morning. I'll probably see you this afternoon on Senate Bill 417.
We're here.
I know.
I will later, after the hearing is over, ask again for people who would like to be considered to serve on this. That doesn't guarantee you'll have a place, but I'd like to know who's interested in it. Sounds like there's going to be quite a bit of work done on that committee.
I think so, Mr. Chairman.
Thank you, Senator.
Well, I think you know, because there's 2 senators that are going to have been on this. And you know the senators do not like to do this, so.
I also know how to divide by 400 and by 24. So, yes.
So good. Thank you very much.
Chair recognizes Lisa Mascio. And your faithful friend, Cassandra Sanchez. Well, you make a great entrance, by the way. That was really good.
Wow, thank you.
You're welcome.
Good morning once again.
Good.
And for the record, Chair, Cassandra Sanchez, child advocate for the state of New Hampshire. And we are here today in support of Senate Bill 459. Initially, it was, thank you. Initially, this was a bill relative to the child abuse and neglect laws, and currently has been retitled to establishing a committee to study the Child Protection Act. The OCA is in support of this new title and moving to a committee to study. I will share a little bit of a background very briefly of what brought us to working on this in conjunction with the sponsor, Senator Carson. The Office of the Child Advocate utilizes a safety science system mapping review process. And our last system mapping review we conducted was in August of 2023. And this mapping was taking a look at, we received in a short period of time between February and June 2023, 9 calls to our office about non-ambulatory infants with serious injuries, physical injuries, broken bones, many of those included children with multiple broken bones at different levels of healing. We conducted a mapping on 3 of those. We pulled out 3 of the specific cases. And in our mapping, we identified that, so for a learning point first, we identified that these children did present to expert doctors, and those expert doctors were able to do imaging that showed that these broken bones were at different levels of healing, and that all of those 3 cases, those children were returned home to their families with no identified reason for the injuries and no identified perpetrator, but with the primary caregivers being the biological parents, and no external caregivers having been providing care within that time frame. So what that tells us is that these very, very vulnerable young children who cannot speak up on their own behalf were sent home to potential perpetrators and put in unsafe situation because there was no intervention able to be in place with those perpetrators because the courts had dismissed the petitions that the agency filed. And so in reviewing that, during this review, we included professionals from the medical community, law enforcement, provider agencies to really take that holistic view of what went wrong for these children, what systemically should we be looking at to build up to avoid these instances from happening in the future. And there was a lot of discussion around the current state of the abuse and neglect laws in New Hampshire being quite outdated, not taking into account these, when we're talking about young children who can't disclose and there's no other explanation given, but there's not a perpetrator. There was also concern for, excuse me, so we also had concern for the safety planning process and conversations between medical providers and the agency and law enforcement and sharing of documentation. So ultimately we came out of that review with recommendations, one of them being particularly around looking at the abuse and neglect laws, ensuring that they're up to date with trauma-informed care, ensuring that we're taking into account the emotional and psychological impact to children when abuse and neglect occurs. Also acknowledging the fact that there are many children that have resiliency and they do not necessarily present in a way as though they are traumatized, but the resiliency is the only thing getting them through. And we need our laws to acknowledge that although a child may be attending school every single day and may have straight A's and doing well, does not mean that there is not underlying trauma that needs to be treated and there's not an impact from what had occurred to them in that family home setting. And that can have a greater impact as they age if untreated. And so that was a lot of the goal here, was taking a look and ensuring that our laws are up to date. In that search, we also took a look at the abuse and neglect laws in many of the other states across the country, pulling out some specific language from states such as New Jersey, Colorado, there's one more, but really comparing many of the states and looking at those that had them laws that were either changed within the recent years or more up to date with what current science is telling us for the impact of trauma on children.
And I just wanted to point out one section that has raised concerns as far as transitioning this bill into a study committee. RSA 169C12F, the rebuttable presumption of harm, is sunsetting July 1st, 2024. So one of the things that SB 459 was doing was repealing that sunset. There was also some updates to that section, but I did just want to point out to you all that SB 498, Senator Bradley's bill relative to the Department of Health and Human Services and DCYF, also includes a repeal of the repeal. So 169C12F, if Senator Bradley's bill passes with that section intact, will remain in effect as it currently is. We would obviously like to see some updates to it. The opiate section is a little outdated, as well as we had added a section about this physical injury to non-ambulatory children.
To your knowledge, Councillor, what committee has that bill?
That bill has already been sent to the floor. It was actually pulled off the consent calendar last week.
Oh, yeah.
So we just wanted to bring that to your attention because we know you have your eye on these issues. So if you could keep an eye on SB 498, that repeal of the repeal, which I believe is section 8, I think it's the very last section of Senator Bradley's bill, that really needs to pass somewhere, either in 498 or if not, put it back into this bill somehow, because that rebuttable presumption of harm is a really important section. There's some really important language around domestic violence as well that was worked on years ago. So just keep an eye out on that if you could, because we don't want that to sunset completely. So we just wanted to bring that to your attention. But, having this study committee, we did just want to give you a little bit of context. We obviously will come visit the study committee and bring all of the information that we had put originally into the bill and the rationale behind it.
Any questions? Representative McMahon.
Thank you, Mr. Chairman. Attorney Marcio, relative to the handout and also your professional associate, that you just handed out, specific to the system review mapping where 9 were identified as having injuries and that were not confirmed how they took place. But it indicates here that they were returned to their homes. Was there any continuing, this was 2023 as it states, was there any continuing mapping as to what ultimately took place with the returned children, and something that a study committee that would be addressing on further record keeping on whether they were, as implied here, potentially put back in danger?
So unfortunately, for some of those, we will have no information unless a new abuse and neglect report is filed, because ultimately at that point, when the court dismisses, DCYF no longer has a jurisdiction to work with the family, and so they close out. There are a number of them in which DCYF appealed the judge's decision or was provided more information and brought that back to the courts. And so some of these cases, we do continue to follow any of them that are open with DCYF. The Office of the Child Advocate is tracking them closely and looking for outcomes for those children. There were some of them that they were successful in those appeals or when providing more information to the court, and those children were either safety planned or placed elsewhere. And there were, out of the 9, there were, I believe, 2 of those 9 where charges were ultimately filed against one parent. As law enforcement got further into their investigation, they were able to gather more information, and so the child stayed with the parent that law enforcement deemed safe, and the other parent was incarcerated at that time. So we picked the 3 to study in the system review mapping that had a lot of similarities to them in the outcomes, as opposed to looking at the full 9, because it would have been too complicated to try to address one giant issue with many different factors playing into it. But we do follow those outcomes for anywhere there is tracking in the system.
In the case you cited where the child, upon x-rays, had injuries that occurred on different occasions, would that lead your assumption to be that it was in the home that those injuries occurred with dangerous parent or parents?
Yes. Based off of the findings in the review of the medical records that we were able to see, it does appear that the medical team said that there were indications that it was caused by child abuse, and that there was no reasonable explanation provided. The medical team, separate from law enforcement, does sit down and talk with the family when a child is going for the additional skeletal survey, asking questions, asking what could have happened in that home. Is there anything they could think of? And they were unable to. There was only 1 out of those 9 cases where a reasonable explanation was provided. And in that one particular case, the child had been rolling off of a changing table, and a parent grabbed whatever they could grab to catch the child from falling on the floor. And when explained to the medical professionals, and they did their extensive workup on that child, they did find that injuries appeared that they could have occurred from that type of injury, of a grab of a limb.
Being a part-time chief executive officer of a family practice medical center and aware of how these various issues not only play out in Concord but around the country, I am familiar with a case where the equivalent department rushed to judgment, and it was later determined by finally interviewing neighbors that the child in question was always jumping where the child shouldn't have and falling, and these injuries were over different time frameworks, and it was not the parents that inflicted it. And one would hope that the preliminary assessment of possibilities would not rise to the level of rush to judgment.
Absolutely. And there, in my understanding of the way in which the division manages these cases, when they do come in, they initially, if they have concerns and additional skeletals needed, that can take up to 2 weeks to be done and the imaging to come back, they will ask the family to come up with a safety plan for the child. So rather than removing the child from the home, they may ask a aunt, uncle, grandmother to move into the home and be the supervisor to ensure nothing else occurs. Or they may ask, depending on the family situation, could the child go and stay with a family member and the parents have time spent with the child under that family member's supervision? And so in none of these cases did we see DCYF jump quickly to removing a child. All of these cases included a safety plan first, and then the next step, once they had additional information from medical providers and law enforcement, then looked to filing petitions in the court.
Believe me, as supervising my staff, I know it's not easy to do. Any questions? Yes, Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking another question of mine. Just looking at lines 14 and 15, Roman numeral 3, study the expansion of the child abuse reporting requirement to include healthcare providers who treat a child under 13 years of age for a sexually transmitted disease. Could you please expand on that a little bit and help us understand where the 13 years of age was, why it's 13 years of age? Thank you.
This was just one little section of the bill. It was actually the final section. It aligns with nationwide practice that they've expanded reporting for medical providers that any child, and that was just sort of the standard age. I mean, it could be 12, it could be 11, but really an age where a child would not be sexually active in any way, and that providers would automatically report. It actually has to do with sex trafficking as well as child sexual abuse. So there would be a sort of presumption that we need to look into that if it's a child of that age with issues. And it came out of conversations with medical providers here in New Hampshire, sort of asking, like, we'd like to align better with nationwide practice.
Can I have a
Follow up, yes.
Thank you, Mr. Chairman. Thank you. Yes, and I completely agree and encourage. Encourage is the wrong word for that, but I completely agree and understand why this would be included. Would the age of 13 be the cutoff date because after the age of 13, there's certain privacy protections for the juvenile?
It would really be more where there'd be a strong presumption. It doesn't mean a medical provider might not see a child of an older age and still make a report, but it was sort of finding an age where, like, there's really no reasonable explanation why that child would have a sexually transmitted disease. I think in conversations with those medical providers, though, they are a mandated reporter. I mean, they may still be reporting at other ages, but this was sort of creating a presumption.
Representative Ball.
Thank you, Chairman Pearson. You mentioned the section on the rebuttable presumption, and this came up before and I couldn't quite figure out how to ask the question, so I'll try it again. I was understanding that that whole rebuttable presumption was kind of put in there as kind of a test drive or something, which is why it had a sunset. But now we're taking a sunset off, and I'm just curious, before we take a sunset off, should we be collecting, or should we have already collected data to make sure that there's no unintended consequences from putting that in to begin with? And why are we going to keep doing it? And in particular, because we did such a big kind of study into the family court system, and that's where my head is stuck. I just keep wondering if the rebuttable presumption is in any way being used within the family court or being weaponized within the family court. And that's what I'm wondering, if this study will cover that to make sure that that it's not being used in a way to hurt families where that's not the intent.
So this section is in 169C, which is only the context of a child abuse case. This is not used in family court, say in a parenting case or a guardianship. So it's limited to 169C. From all the conversations we've had with DCYF attorneys and workers, advocacy groups like the Coalition, and other groups, providers, the presumptions that are currently in place are very important and necessary within that child protection arena. And I'm sorry, I don't have the language of the current presumption with me. 459 had made some changes also based on conversations with DCYF attorneys, workers, medical providers, coalition, other advocacy groups. But as the presumption currently stands, there is wide support and feeling that it's very important to keep in there. And again, it's just in the context of abuse and neglect cases when there is a concern for child abuse. It's not used in parenting cases.
And particularly, just to add briefly to that, particularly in these cases, that rebuttable presumption can allow families to stay together, because when we're talking about domestic violence cases specifically, a child witnessing domestic violence is impactful and is a traumatic event to them. And so if there is a parent who is attempting to act protectively but is in fear to take certain steps to remove their family from an unsafe situation, the court can weigh that actually this parent, although they may not have removed their child from the situation, was acting and attempting to protect their child. And so that mother does not need to be removed from her child and the two of them suffer further trauma. Rather, that mother or the father, either side, could remain with that child and be supported to separate from the abuser in that situation. So ideally, that child should be able to remain, and the court takes into consideration the importance of their ability to remain with a primary caregiver who is not abusive to them or the other primary caregiver.
And it's still a rebuttable presumption. It just weighs the factors differently in very specific, very limited cases. It's pretty narrow.
Follow up.
Just to follow that up. So I guess what I'm concerned about is in those cases where it's being brought before the family court when they're determining family, parenting time, that if there's an investigation going on that has not yet been proven, I just worry that could then be brought into the family court. So I guess I'm still a little worried about, given what we've seen coming into the family court and parents being denied access to their children and then later finding out that they should not have been denied. That's where I just worry about it, and I understand the intent of it, and I think it's really good. But at the same time, I'm just wondering if we should be collecting data to make sure that it is not being used in a way it wasn't meant to be used.
And again, that's the study committee could certainly look at that. I'm not sure if you could, how you would collect data like that. But again, this section is directed to the court in an abuse and neglect case. It doesn't really actually impact the investigation piece or what would be screened in or an assessment. Most of actually the definitions are the court applying it once the division has already filed a case. It doesn't really affect that prior piece.
I've looked it up, and 169C12F is effective only as recently as July of 2020, so there may not be a lot of history for us to look at just yet.
Yes, and 169C was 12E, I'm sorry, was actually the precursor, which was only in place for a few years. And I don't know why they didn't then just amend E, but they got rid of E and started F. So, but again, I don't know that the family parenting side cases would be collecting any data because these are very specific to 169C cases. So,
okay.
Thank you for looking that up. Welcome. I couldn't carry my book today. It was too heavy.
You people, you know what you're trying to do. And earlier when we wondered if there were enough lawyers, I'm 3 years and 1 month short of getting a JD.
We wait the day.
I know you do. Any questions? Any further questions? Seeing none, thank you so much.
Thank you, sir.
The chair recognizes Pamela, is it Keilig? Sorry? Keilig, yeah. From the New Hampshire Coalition Against Domestic and Sexual Violence. Had a nice email exchange with Amanda Grady Sexton recently. That's your group, right?
Yes, that's us. Thank you very much.
You're welcome.
My name is Pamela Keilig, and I am the public policy specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. Thank you so much for allowing me to speak today. The coalition is the umbrella organization for our 12 community-based crisis centers that serve roughly 14,000 victims of domestic and sexual violence each year, and that's adults and children. I'm here to testify in support of SB 459. I will try to keep it brief, as I think folks before me were very thorough in their analysis. We supported the underlying bill and think this is a really important initiative. And specifically, just echoing what the Office of the Child Advocate said, we really think it's essential that the definitions of abuse and neglect get looked at. We think there's a lot of opportunity to strengthen them, and also have an interest in maintaining the rebuttable presumption of harm in domestic violence cases. Adverse and traumatic experiences in a person's childhood, such as exposure to domestic violence, can place individuals at an increased risk for chronic health problems, mental illness, and substance use in adulthood. So identifying these adverse childhood experiences, or ACEs, and creating support for children at an early age is really critical to breaking the cycle of abuse. While we have long recognized that child abuse causes long-term effects for the child, we have been slower to recognize that the very same effects are suffered by children who do not experience physical violence. So growing up in a household witnessing violence can also affect their emotional, psychological, and mental well-being, as the former presenters shared. And so for those reasons, we really think it's important that we look to broadening that definition to consider those emotional and psychological factors. And unfortunately, and so we think that SB 459 would really help pave the way to having that conversation and making this important change into statute. We have heard from countless victims that the strict interpretation of the statute has had an impact on the ability to take the necessary actions to protect children who are at risk or are experiencing abuse that have resulted in serious bodily injury. That phrase is just a really high bar. And so by introducing a study committee, SB 459 would recognizes that child abuse can take on many forms and doesn't necessarily need to result in physical injury in order to have long-term and devastating impacts. We see this often when working with victims who have been concerned about the abuser's behavior and treatment of the child, but because they had not been physically harmed, the appropriate interventions are not taken to protect them. And so protective parents really should not be forced to wait for the unthinkable to happen to their child before they can act in the best interest of their safety. So I think just again, would love to reiterate just how important it is that we're exploring this and looking into responding to the appropriate patterns of behavior so that we can really take an intervention before something gets so severe. And then just briefly on the rebuttable presumption of harm, as was discussed in 2020, a law was passed that exempted victims of domestic violence from the rebuttable presumption of harm under specifically and narrowly under 169C. And this provision will soon sunset. So we're hoping to see SB 498 move forward as well, if not in this bill is maintained in this bill. And I think this is just a really important provision because it recognizes that the perpetrator alone is the cause of the dangerous environment and in turn is resulting in the harm of a child. Tactics such as making the victim feel guilty about how they care for their children or even threatening to take the children away or harm them can all be used by abusers to try to coerce the victim into staying in the relationship. The victim may not purposely be staying in a dangerous situation to subject their child to domestic violence. It just sometimes isn't safe for them to leave right away. And statistically, research shows that the most dangerous time for a victim is when they're trying to leave a relationship. That's really when things escalate. So I think just having the opportunity to explore this, to look into this and understand the reality of what we're seeing in the state is just so critical. So I'll conclude there and I'd be happy to take any questions, but I really appreciate your time today.
Wow.
I don't know if that's a good or bad thing, but I appreciate your time.
It's good stuff. Thank you for coming. Anyone else wishing to testify on this bill that somehow eluded the pink card table? No? I close the hearing on Senate Bill 459, and now the chair would like to ask any members of this committee being interested on that study group. It's going to be a lot of work, but it's going to be well worth it. Wow. Okay. Maybe I should say who not. Okay, I have Perez, De Simone, Long, going down this way. Ball, I can, I have not missed seeing your hand once this year. I appreciate, this is a cooperative thing. Yeah, I know that. I missed McMahon once, but okay. And Nelson and Greg. Okay, and we'll be taking a look at this bill next week with a few others. I am not prepared to go forward to exec it. There's other things need to be done, and we have some handouts here. Thank you. And thank you, Mr. Burke from Protective Services. You are my phone-a-friend when it comes to Boston sports information. Thank you for coming. And we will come back at 1 o'clock. Before we start the first afternoon hearing, the chair would like to recognize and come up to the witness table Heather Morton from NCSL. She is the liaison to New Hampshire. I was privileged, one of about 15, pretty much equally Republican and Democrat, who went to the national conference last summer. NCSL, unlike many different groups, tries very much to be across the board in terms of partisanship. Lots of people, there were what, 5,000 or 6,000 people there. You can do networking, great speakers. This one, if you like bourbon, is going to be in Kentucky this summer, and we're going out to the racetrack. You don't need to bring your own horse with you. They will provide. So Heather, give us 3 or 4 or 5 minutes about NCSL and why everybody should go to Louisville this summer.
Thank you, Mr. Chairman, and thank you for the introduction. Yes, so I'm Heather Morton, and as the representative mentioned, we are all 50 states, commonwealths, and territories are members of NCSL, and we're unique in that both legislators and legislative staff are equal members. And our purpose, basically, in a nutshell, is that I see it as we're here to make you look good, right? We're here to help you do your job as a legislature, both in terms of legislators and legislative staff. And so on a day-to-day basis, if you are looking for information, like if you're interested in drafting legislation and you want to know what other states have done, that absolutely is something that you can contact me as the liaison to New Hampshire, and then I can find the appropriate person. I do have, we do have, of course, available on our website, we have our contacts list. So if you want to go directly to the issue expert, you can contact them directly and say, I want to draft a bill that, regulates cats. For lack of a better example, what have other states done? And so we can either pull the legislation, we can pull statutes for you, and we are nonpartisan. So our role is that we give you the data and let you decide what is best for your state and for your constituents. And as the representative mentioned, we have our legislative summit is coming up this summer, August 5th through the 7th. Hopefully, you probably received an email from me today. It would have come out this morning announcing the meeting, and we will be in Louisville, Kentucky. And we have, within NCSL, we also have a committee structure very similar to the legislature here and the general court here in New Hampshire, where we do educational sessions. So you get the opportunity to learn of what, some hot topics, and you give the opportunity to network with other legislators and staff from other states. But also we develop position statements that my colleagues in our DC office will then use to do their lobbying and advocacy on behalf of the states to the federal government. And that's through our standing committee. If a policy directive or policy resolution passes there and then it gets voted on by the membership of NCSL and passes, then our position usually is, boils down to no unfunded mandates, don't preempt the states, that kind of thing. But that's the work that my colleagues in our DC office do. So I'm happy anytime that you want to reach out, please do. And I can, like I said, I can find you the issue expert at NCSL. And if it happens to be me, I am happy to answer those questions because I work on financial services, technology, and communications issues. So thank you very much.
Any questions? Yes, Representative DeSimone.
Thank you, Mr. Chairman. This is a real easy one. Can you spell your last name? Absolutely. It's Morton, just like the salt. Morton.
It's just pronounced Martin.
Only if you're from Mass or New Hampshire, and then you go Martin.
Any other questions? We are so blessed to have such tremendous committee research done for us, but it's always nice to know that in case our committee researcher is just absolutely slime, not that we would ever slime you, but just nice to know there's a backup.
Yeah.
But your job is very safe here.
Yeah, and absolutely, we work with the legislative staff as well. So oftentimes, if you give them a research request, they may be contacting us, and we provide them with that information as well. So, but yeah.
Phone number.
Yes, so my phone number is 303-856-1037.
1475. That's my direct dial. And if you like, I can give you my email. So it's heather.morton at ncsl.org.
Thank you so much.
All right. Thank you. And I will be here through about Thursday afternoon. So
We're going to be adjourning before then.
exactly. But if you see me in the halls, feel free to stop me and I'm happy to help. Thank you so much, Mr. Chairman.
Thank you. Open the hearing for Senate Bill 574. 574, yes. And what is it? Turning in our hymnals to 574. The relative to the appointment of a temporary agent for a minor child or incapacitated person. And the chair calls upon Senator Chanley, the prime sponsor, who's already passed the first test of CFL committee. You've turned on the mic.
Yes. Thank you very much, Mr. Chair, members of the committee. My name is Shannon Chandley, and I serve the people of District 11 in the state Senate. I bring before you today to introduce SB 574 relative to the appointment of a temporary agent for a minor child or incapacitated person. I bring this to you hoping that you will look favorably upon it. It really is a way to resolve a problem that some of us have probably had and not necessarily been sure how do we handle a situation in which we might be leaving our children for a short period of time in the care of another. And I know many of us have written notes to say that my sister, my neighbor has permission to seek care for my child, or we've done that because that is all we knew to do. This allows for a form to be created, but for folks who wish to leave a child, say a couple chooses to go on vacation and is leaving their child in the care of a grandparent. This recognizes that they are leaving the child in the care of a grandparent, and the grandparent has certain rights to make decisions during that period. And mostly we're thinking about medical emergency decisions and such. But it also would recognize things perhaps like picking the child up from school and other issues that would come up. When the bill was first filed, we had some testimony from the Coalition Against Domestic and Sexual Violence and the Office of the Child Advocate that said, well, this is a good idea. And, you know, people generally saw the need for it and recognized that it was a reasonable idea, but we needed to put some safeguards in place to make sure that this did not first interfere in any way with court-appointed guardianship, and that it also recognized that there are situations where there are intense fighting or disagreement between parents, and we needed to make sure that no high-risk situations were created by us not including some language in this bill that would recognize that folks who were in those situations being investigated for abuse and neglect, for example, could not be assigning their children to the care of another. So I'm happy to take any questions, but I also want to mention that my constituent, who really was the impetus for this bill, is here, and I'm sure can talk to you more about how this is handled in other states and why this is a good New Hampshire approach to doing this. Thank you.
Any questions for the senator? Seeing one, Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. It's a quick one, and I just wanted to ask you if both parents would need to give permission for this to happen.
And I believe that is addressed in Section 3, lines 13 to 18, I believe, says, if there is no, dealing with when if the parents are not together and there's no parenting plan in place, a parent or guardian may not appoint a temporary agent if the minor has another living parent whose whereabouts are known and who is willing and able to safely provide care and custody for the minor, unless the non-appointing parent consents to the appointment in writing.
Any other questions? Representative Raymond.
Thank you. So I just want to make sure thank you, Mr. Chairman, and thank you for taking my question. I just want to make sure I understand. So currently, a parent does this already by typically they can write a letter. Sometimes they get it notarized, etc. We've done this in my family because I had surgery and my in-laws came to take care of myself and my kids while my husband was out of town. This will change it so there's a standard form that someone could download?
We could create the form, or we could just have this law could exist as it is. It gives some protection to the parent who leaves the child in the care of another, and also some protection to the person with whom the child is left.
Okay. Thank you.
Seeing no further questions, thank you, Senator, and we
Thank
will
you.
see you in Judiciary very
Okay,
soon.
thanks a lot. I'll look
Try not
forward
to have
it.
too much fun until we get there. Chair recognizes Peter Mustakis from Amherst, and I believe you are the one the senator referenced as being a prime mover behind this bill.
Yes, I am. Thank you, Mr. Chairman, and thank you, representatives, for hearing me. And if I could briefly address Senator Raymond's question. Right now, people just write a note, has no legal or binding authority, so it means nothing. This SB 574 would give some gravitas, some weight to that. SB 574 is modeled after a Massachusetts general law, which allows for the appointment of a temporary agent for a minor, a child, or incapacitated person. But the Massachusetts legislation, that was modeled after the Uniform Probate Codes provision. So back in the 1950s, 60s, there were a bunch of educators who got together and thought about what's the best way to treat this. They came up with some model guidelines. The majority of the states have adopted the model rule. This SB 574 is a bit more nuanced than the model rule. The model rule is more vague. It's 2 sentences, and it can last for up to a period of 2 years in which you can give or delegate parental authority. SB 574 limits it to about 60 days. If you need to re-up it, you can re-up it by signing a new form. But this is something that is common throughout many states in the country. New Hampshire is one of the few that does not have this. I am a practicing attorney in both Massachusetts and New Hampshire. I have used the Massachusetts legislation to benefit many of my Massachusetts clients, but when it comes to New Hampshire clients, we are unable to use this. The idea really is mom and dad want to leave their child with a grandparent or cousin, or in my instance, my brother and my sister-in-law have my kids for this school vacation week. And should something happen to the kids, if they need to go to the hospital and get emergency treatment, this law would allow them to have the authority to get that treatment.
Representative Panic with a question.
Thank you, Mr. Chairman. Thank you for taking my question. If we can already get an affidavit to cover that, why would we need a law now?
Sure. That affidavit has no binding authority or legal hold, so it means nothing.
Thank you.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my call. I'm still a little bit stuck on the language of lines 13 through 18. So if the parents are together, both parents would have to sign off on that they're giving permission for this temporary agent. However, this says that if the parents have a parenting plan, that the parent who has the parenting time has the sole decision making, and you only need one parent to give permission. Both parents won't have permission, are not needed to have permission for placement. That's what I'm reading here?
Yeah, so that was part of the amendment made after the Senate hearing. And my understanding of that provision is it's intended to say if child's on your parenting time, go ahead and make a plan. And you can go ahead and decide what should happen since you already have parenting time availability. There are paragraphs further down that try to protect and say certain times you cannot appoint someone to receive the care of your child. So if you're parenting time, your call. If it's co-parenting time, both parents, my understanding, need to approve.
Follow up?
I did read. Thank you, and thank you for taking my next question. I'm sorry. I did read further down, and this is this would be like in surrender of parental rights or in a high conflict situation or whatever. But if it's a harmonious parenting plan, but one parent just disagrees with a placement, that will not be regarded at all.
I believe that was one of the primary concerns from the New Hampshire Coalition from Domestic and Sexual Violence and the Child Advocate for New Hampshire. And they were most concerned of that, and they're the ones who drafted this piece in there to fit that concern. So I think it takes care of it.
Any further questions? Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. I'm really stuck. So we have parents who really don't want to be parents, but they don't want to go through the expense of putting their children up for adoption. So they use this, which says not for a period not exceeding 60 days. So I'm one of those parents. I'm not, but I give my kids to you for 60 days. On the 60th day, you bring them back to me. They spend 2 nights with me, and then I call you and say, come get your kids. And for 60 more days, they go and stay with you. And you're not a good person because you know that I'm not a really good person with these kids. And maybe you're sex trafficking these kids. How do we prevent that with this?
I think you have the same problem now, regardless of whether this.
You do.
So
So how does that stop that?
I don't have the answer to that question. That's a good question.
Thank you. Thank you. I appreciate your time and I appreciate you going along with, but that's my concern. Thank you.
Okay.
Thank you. That's directly Mr. Vice Chair. Thank you for taking my question, for being here. So I guess I'm sitting here and I've done these things before, like notarized documents and stuff, like I'm going to be gone. My kids are with my dad. This is my insurance information. So tell me, without this law, that happens. My kids break their arm. My dad takes them to the hospital and he has this notarized thing. Why is that not binding? Like, what happens then? Like, they can't be cared for? Like, tell me what happens in that scenario without this law?
Yeah, without this law, the doctors have every power in the world to say, I can't treat this child because there is no law requiring me, or there's no authority there by this person to approve the medical treatment for the child. It's just a notarized piece of paper. Anyone can notarize anything. Doesn't mean there's gravitas or legal authority behind it.
Follow up. So do you have a situation, like a real life example, not just an idea that it could happen, where this has been a problem and this has actually happened, like that it really did, that doctors really were like, no? Or can you give me a real world example?
Yes, one of the other people who are here to talk has a real life example that they are willing to share.
Any further questions? Seeing none, thank you. Oops, I'm sorry. Oh, Representative Panic.
Thank you, Vice Chair, for allowing me to ask a question. So what you're saying to this whole committee is that an affidavit, a notarized affidavit, is worthless.
Yes.
So
When
what's the
you
point-
have-
So what's the point of even having notary republics?
So when you have a notarized affidavit, it needs to point to some kind of law. It needs to say, this is the law I'm referring to, and I want so and so to happen based on law XYZ. For example, let's say it's a HIPAA release form. You sign a HIPAA form, you get it notarized, that's fine, but you're giving someone the authority to have your healthcare information based on the 1996 HIPAA law. You can, if you are writing something down and just saying, I wish for this to happen without any kind of law like this in place to say, there is something we are pointing to that the state specifically allows for such a thing to occur. It is meaningless. And a notary, whether it's notarized or not, the substance of it, there is no gravitas to it without a law behind it.
Thank you for answering my
Representative Petrino.
Thank you, Mr. Chairman. Quick question. Where would parents get this form? How do they download it? How do they become aware that it even exists?
Sure. That I leave to you all. And my hope is that there is a form attached to the legislation that can just be downloaded, just like we do with the power of attorneys now or the power of attorney for healthcare. There is a state promulgated form that people can just download off the internet and use. And my hope would be that, whether it's this piece of legislation or if there's something down the line, that does happen. It just makes it easier if people can just download it off the web.
Further questions? Seeing none, thank you.
Thank you.
The last card I have is Daniela Chrisman.
Good afternoon, and thanks for having me. My name is Danielle Chrisman. I am a resident of New Hampshire and a mother of 4 minor children. My parents live in Kansas, and every summer, a couple of my kids will go spend about a month with them. And so that's kind of where this came about, because a couple years ago I said, "Hey, Peter, is this something you can do for me?" And he said, "No, because there's no law that says the doctor has to follow these wishes." I'm like, okay. We are lucky enough to be a military family, so I just went on down to Hanscom and had the attorneys down there draw one up for me using military laws. Last summer, my oldest daughter actually got an ear infection, and my mom had to take her to the urgent care, where they very much wanted to see that my mom had permission to get her treated. And so that's where the importance has been for me. So thank you.
Petrino?
Thank you, Mr. Chairman. I may have missed this. Did your daughter receive medical treatment when she was in Kansas?
She did.
Okay, thank you.
Under the military.
Under the military. Okay, thank you.
Further questions? Representative Gregg?
Thank you, Mr. Chairman, and thank you for taking my question, for sharing your story. I appreciate that. So so the lawyer wouldn't do the draft this document. She had the document, right? Like she had the document when she took her to the doctor for the ear infection.
Yes.
You already had it done.
Yeah, I had already had it done down on Hanscom.
Okay. And the attorney wouldn't draw it up until you used military law. Is that right?
Correct. Yeah, they used military law on Hanscom.
Okay. All right, that's it.
Further questions? Seeing none, thank you.
Thank you.
Seeing no more cards, I'll adjourn the hearing on 574 And 2:00 is our next hearing, which Representative DeSimone will be chairing,
Thanks a lot, best friend.
because I got a 1:45.
Be on your way.
At the Senate, actually, his is before ours, and the one before the both of us is the child support bill in the Senate, so that'll probably be a while.
Yeah, it will.
Oh, we'll be back by then. Yeah, we'll exec that to 30th. Yeah, we're recessed until 2:00 is our next hearing.
Good afternoon, everyone. We're going to call this meeting to order. Please have a seat. And at this time, I will call Senator Whitley forward. Is the clerk ready? The clerk is ready. Senator Whitley, thank you for coming this afternoon.
My pleasure. Good afternoon, Madam Chair and members of the committee. For the record, my name is Becky Whitley. This is Pink Day, I'm just noticing. Oh, geez, I should have gotten the memo. For the record, my name is Becky Whitley. I'm honored to represent Senate District 15, which you are sitting in right now, the wonderful city of Concord and the surrounding towns of Bow and Hopkinton. So today, I am very honored to introduce Senate Bill 417. This is an incredibly important child welfare bill.
Can I ask you to suspend for just a second because I did not properly open the meeting?
Sure.
Thank you for doing that. We're opening the meeting in the hearings on Senate Bill 417 FN, and Senator Whitley is the prime sponsor. And thank you so much for indulging me. Go ahead.
My pleasure. So 417 is a very comprehensive, it's a big bill. I do understand there's a whole lot of policy in here. I will do some introductions of the bill, but there are people behind me that have worked very hard on the version that you see in front of you, and they can do the sort of deep dive into every single provision and how we got in there. But generally, it's a bill that advances strategies based on solid evidence. And I think that's how we should be legislating, with evidence that we know is going to keep our children safe. So many of the changes that you see here were sort of put under scrutiny in the Senate, and there was a whole lot of work done. There was a very collaborative process between the Office of Child Advocate, the other advocates, child advocates, and then the Department of Health and Human Services. So I just did want to note that there's been a lot of collaborative work here done. So as this committee may know, my life's work as a lawyer, as an advocate, and now as a state senator has been on strengthening families, building stronger communities, and ensuring access to opportunity, because it is very true that children and young people need all three to succeed. In particular, I do feel that we have a moral obligation as leaders to support vulnerable children and families, an obligation that very seriously, as I know so many of you do also. So this legislation was in response to a pretty horrific situation that all of us are aware of. In August 2023, there was an investigation by the Office of Child Advocate and a detailed report on the mistreatment of New Hampshire youth placed at the Bledsoe Youth Academy in Gallatin, Tennessee. So as you may know, when children are involved with the Division of Children, Youth, and Families, Developmental Services, or Bureau of Children's Behavioral Health, and require out-of-home placement, and foster care may not be specifically a match for them due to certain behavioral or developmental or mental health needs, they're often placed in out-of-state residential facilities. There are some that are placed in-state, but it is still the case that many of our children who are our most vulnerable to out-of-state facilities, out of reach for advocates, out of reach for families, communities, and folks who are here to keep children safe. These facilities are intended to serve as a temporary residence with therapeutic treatment to assist the child in gaining skills to better manage their behaviors and emotions so they can return to a community setting. That's the goal, to get them back in their communities, back with their families. Prior to placing children out of state or in residential facilities, all family, foster, and in-state options are supposed to be exhausted. This is because many children referred to residential treatment have suffered years of trauma due to exposure to substance use, mental illness, domestic violence, and abuse and neglect by primary caretakers. Again, these are our most vulnerable children. Tragically, the OCA's report detailed deeply upsetting and troubling conditions faced by the New Hampshire children at this Tennessee facility, including reports from children that staff offered them incentives to assault other children, cameras in bedrooms leaving children with little privacy to change, and children suffering rug burns while restrained face down on a carpet. Again, our most vulnerable children. The OCA's report detailed that the facility appeared dirty, had little recreation space, and was defined by a culture of shame, humiliation, and inhumane punishment. As an example, the OCA noted in her report that the staff at the Tennessee facility could not explain the complicated point system that determines a child's privileges and punishments. She noted children were dressed in color-coded jumpsuits based on behavioral needs or punishments, a system that communicated personal information to all staff and kids. Just humiliating. It's important to note that this all occurred in the context of ongoing litigation against the state, where plaintiffs are alleging that the state is over-reliant on congregate or institutional settings. Now, I just want to point out the bill before you does not address every single problem identified in the Bledsoe report, but it is a very critical first step. Experts tell us that the most effective way to help children is to involve them with their families, friends, community members, and professionals in all the decisions related to out-of-home placement. So specifically, this legislation codifies certain policies, prioritizes keeping children with their family and in their communities. Those are the broad principles that we're working on from here. The bill also strengthens the existing statutory preference for in-state placement of New Hampshire children removed from their homes and strengthens the requirements around residential placement of those children. And also strengthens the existing mandate for siblings to be placed together when removed from the home, and a whole host of other things, again, that the folks behind me who have worked very hard to put this comprehensive bill together can speak to further. I want to thank DHHS, the Office of Child Advocate, and the JRPG, the group of advocates, fierce advocates, for their commitment to children and their ongoing work on this bill to ensure it adequately protects children. Thank you for your consideration of SB 417. I'm happy to take any questions, but again, I will defer all technical questions to the folks behind me, and so I can get back to my own committee. Thank you very much.
I was just there.
You were just there, and we were talking about the same thing, weren't we, Mr. Chair?
I don't remember.
No, okay.
Any questions for the senator? Seeing none, you may go back to judiciary.
Okay, thank you. And I would ask, because the folks behind me do want to go testify on your
I know
bill,
they
Mr.
do.
Chair. So if I could ask that the Office of Child Advocate goes first, that'd be great. Thank you so much. Appreciate it.
We all passed in the hall. Thank you, Senator, and the chair recognizes Cassandra Sanchez from the Office of the Child Advocate.
Good afternoon. For the record, Cassandra Sanchez, Child Advocate for the state of New Hampshire. I would like to take a moment to thank Senator Whitley, Senator Pearson, yourself as well, for being a sponsor on this bill. I apologize. Oh my goodness. It has been a long day already. Representative Pearson, thank you very much for being a sponsor on this bill as well, as Representative Grossman, who is not available here today, but very grateful for the work done to support the children of New Hampshire in residential placements. So as you heard, I won't get too deep into the details of the report from Bledsoe Youth Academy, as we heard a bit here already from Senator Whitley. But that really was the impetus to this bill, knowing that unfortunately children suffered quite a bit of trauma at that facility after already being traumatized in their home environments prior. And we know this is not a standalone. Unfortunately, as was also mentioned, there are many lawsuits. This has been an ongoing issue where we don't always see the most adequate level of care provided to our highest need children who are placed in residential facilities. I will get into the bill a bit for you, hoping to break down the different sections and explain a bit more the importance behind these different sections that we have here. So the first section of the bill strengthens the language around when a child would be appropriate for residential placement. We do understand, I believe it was mentioned earlier today, that we place quite a bit of children in residential care here in New Hampshire. The last update that I have from DHHS was on Friday at the Oversight Commission on Children's Services, and at that time, just under 30% of children in placement are placed in residential care. That is much higher than our neighboring states and much higher than the majority of the country. And we truly do need to take action to reduce that, ensure that the care that children are receiving in residential is adequate, it does meet their needs, and it is short term. So that first section there really focuses on that and ensuring that children are going to placements that are tailored to meet their particular needs, and that they will move on to a more appropriate community-based placement when their treatment has been completed. Section 2 addresses the issues of siblings in placement. Although it is DCYF policy, we still do observe cases where children are separated from their siblings. We did have a case this fall, which resolved early this year in January, where there were 3 siblings that were placed separately. 2 of them were placed together, 1 was placed in a separate foster home. The entire time the Office of the Child Advocate was working with this sibling group, they continued to advocate for wanting to be together. They begged and pleaded anybody and everybody that they could speak to show the importance of that sibling relationship and show that they have such close bonds that that outweighs any permanency for any of them. Ultimately, the older children were able to speak to the judge and voice their interest in being placed together with their siblings. And ultimately, it was after this presentation to the court that the judge ruled that there should be another matching meeting for permanency for these children, and the consideration of their sibling bond needed to be in the forefront. It took court action to get there. We should not require that action. These children spent months apart from each other, worrying about the safety of their younger sibling. Our children need to be with siblings whenever possible. This would codify it in law, and beyond the policy, it would enforce that the agency needs to follow the policy around keeping siblings together unless there is a safety issue. Of course, there are going to be circumstances where children may not be safe to be with each other. They may need treatment before coming back together. But unless there is this outlying safety issue, we should always be prioritizing that sibling bond. Section 3 addresses issues that we have seen with non-custodial parents. So this section here truly is to address what we have learned from the Office of Child Advocate in Massachusetts in response to the Harmony Montgomery case. What we learned in response to that case from their office is that the court placed the child with the father without doing due diligence into the father's fitness, without the state of New Hampshire being able to complete a home study and ensure that the home and the other adults living in the home would be safe for this child, because at that time the judge determined that New Hampshire state law did not require that level of review of a biological parent. So leaning on New Hampshire state law, that judge sent Harmony to live with her father. And we all know the gruesome outcome for that child. And in the spirit of learning from issues that have occurred in our state and wanting to protect children, took this opportunity while looking at this area of statute to say, now is the time to act on this and really ensure that DCYF can have an opportunity to do a full view into the non-custodial, non-accused parent, ensure that they understand the child, not only the child, but also their unique needs, and can represent to the court that they can meet those unique needs and can provide for safety of that child before the child is sent to live with them. So this is a very critical piece of the bill. I do want to make sure it is very clear that this is specific to 169C, abuse and neglect cases. This would not cross over to the family courts. In section 4, we add section G and H into 169C19. So the new section 169C19G that we're looking to add here is taking a look at state-sanctioned evaluations and examinations of children in state care. Currently, there are programs that do assessments in the state, and when they're doing their assessments, the outcome is to inform next treatment steps for that child. Some of these programs are known as CAS programs, comprehensive assessment and short-term treatment. So the child is residing at the program while they're having assessments done by staff there. In talking with an expert in the field in New Hampshire, we learned that oftentimes these assessments are done by lower level clinicians that are not trained to do personality level assessments. Those should be done by a psychologist, and particularly one who has an expertise in childhood trauma. What we see when these are done by non-qualified individuals is that the ratings can, at times, have negative implications on the child's placement. They may rate the child to have a personality disorder that a psychologist is saying is not accurate. And now that is going to follow the child to whatever next placement they're seeking to get into. And many times it can disqualify them from placements because of what is in that write-up. And so in working very closely with this expert, she came to us with some language that would assert that it is, if those personality measures are going to be used, that they are completed by a psychologist who has the experience, who takes it very seriously that these are measures that will follow the child, and ensures not to put anything in writing that would lead to the child being denied from placements in the future, but rather allow the opportunity to speak to maybe some behaviors and personalities that they're seeing, but not diagnosing that child in that moment, particularly when it's short-term. Personality disorders need a lot longer time to be spent with the clinician for them to be able to assess and meet that level. And so this cleans up that assessment process and leads to, hopefully would lead to better outcomes for our children and getting thorough assessments by an appropriate level clinician who can then make treatment recommendations that will provide the right level of care for that child moving forward. Section H is 169C19H is the order of preference for out-of-home placement. This is the core of this bill, is around this placement preference. This speaks to the importance of keeping children intact with their families whenever possible. And it aligns with the mission and the vision of DCYF, where they do seek to keep families intact and provide services to meet those family needs before having to remove children from the home. But if that is unable to be accomplished, it speaks in an order of preference for placing a child. And that begins with the placement with a kin, somebody who the child is familiar with. That would be inclusive of fictive kin. So anyone who the child has a pre-existing relationship with. It could also be someone who has a pre-existing relationship with the family system, and as well as blood relatives. After kin, then we get into foster care options. And it speaks a lot about proximity. Proximity is key because our children, when they are pulled away from their homes, they lose all of those connections that they have. They lose friendships. They lose trusting adults. All of those people that are looking out for them protectively are now stripped from their lives. If we can keep them in foster homes or kinship placements that are in close proximity to their home where they first had come from, then easing back into that setting in the future should be easier. Friendships would be there. Schooling and trusted professionals at school will be there and ready to support the family as that child transitions back home. And it speaks to leading down to residential placement being the highest level and only necessary an appropriate level of placement if that child's needs require it. And again, pointing to the importance of that short-term treatment episode and then the child to return to a community-based setting. There is also a note in there about the preferred age of children. We have seen some very young children end up in residential care as young as 5 and 6 years old. Not necessarily a healthy placement setting for them. And ideally, we would like it to be framed for children in the older years who are able to accept the treatment and move on from that. And so ideally, it should be 12 or above. That is the national standard at this point and there are some states that have actually outruled any placement outside of a home-like setting for children who are under 12. We are not looking to go that far at this point because we do understand that there are some children with very high needs, and our younger children are presenting with higher needs sooner than they had before, but like to keep in mind that the age of the child and the environment that they're exposed to will have implications for them future down the line. Section 5 talks to some changes as for the standard of return to home. And this shift is truly just to ensure that when looking to return a child home, that the child is returning to a parent who is safe and able to care for them and able to provide for them. Currently in statute, it is based off of the reason for the child coming into care, and has the parent made changes to show that those issues no longer exist. Yes, that is important, but in keeping with trauma-informed care, it also needs to be an environment that is going to meet that child's need. And when children do come into care, they suffer additional trauma, their needs do increase. And so the parent may do some great work on themselves, but have they done the work to know where their child is at now, and what ability do they have to meet that need? And so that's where the focus is, making it a more holistic view where it's not just based off the parent, but it's also based off that child, ensuring that that child's best interest is in the forefront of all of our legislation moving forward. So please feel free to join me. Would you like to introduce yourself?
Lissa Massio, Associate Child Advocate.
And apologies, running in from the Senate.
Who said I couldn't be two places at once?
And so it is important to note in Section 6, it mirrors the language of Section 1 and 4 into RSA 169F. The importance of creating that in 169F is to ensure that these provisions for placement preference also impact children in 169B and D cases. So those are children involved with juvenile justice, as well as the children in need of services. All children who could end up in a residential placement should have the equal opportunity to be in a community setting first. So we wanted to make sure that this was not only having an impact on children in abuse and neglect cases.
No, I did that already. Okay. Okay. Where to my section?
Take a breath.
So, also in section 6, there are two new sections which you may recognize originally were attached to 1573, where I just was.
Me too.
So they were moved over here into SB 417 because there was a lot of cross references to the increased oversight, and it sort of made more sense to have them on this bill. So, and we did do quite a bit of work with DHHS and the judicial branch in-house finance for 1573. So these two sections have actually been pretty substantially revised from when you last saw them back in February to balance the load on current workers with the safety of the children. So looking at them, the language has been shifted a little bit, but these monthly visits from DCYF workers, if you recall from our Bledsoe report, there had been 7 workers at that facility over 7 months, none of whom raised a red flag about what was going on there. So after talks with the division, with workers, with BCBH, decided that that was a place that could make change fairly easily. These monthly visits are already happening. They're paying the workers, they're paying for the travel. But by refining that section, making sure it's a worker that the child knows, either the worker assigned to that child or someone who knows the child. It could have been the assessment worker, it could be a supervisor. But having that trusted relationship is a lot more likely for that child to feel comfortable to make disclosures about what's going on. In addition, we found out at Bledsoe that the visits were about 15 minutes long. They took place in just a little conference room off the lobby with the kid with a person they'd never seen before. So we did want to enhance those visits. And this isn't to say most workers don't do this. I mean, a lot of workers we talk to already do this. You're walking around the facility because you want to make sure to see where the child is sleeping, where they're eating, if there's education there. While you're walking, it's either a member of leadership or a direct care staff walking with you. You're chatting. How's the kid doing? How's your program culture? What kind of disciplinary tactics do you use? Wanting to see any seclusion or quiet rooms in the facility is very important. So we worked that into the language here to make sure that it's clear, and also created a new form in conjunction between DHHS and OCA to make sure that everyone knows what they need to be doing and it's being done consistently for the safety and welfare of that child. The last section is that court oversight piece. Again, this was edited a bit to sort of lessen the load on the judiciary as well as the workers attending these hearings. So it continues to have a lot of the language around what information the court needs, because the court's been telling us, we're placing these kids. We don't really know where they're going. We only have, that DHHS is telling us that's where the kids should go. We'd like a little bit more information. Why is this child going to that placement? What's special about that placement for that child? As well as what are the continuing updates on that child? We had initially wanted to see more frequent hearings at 30 or 60 days. That was going to be a real burden on both the judiciary and the division. So instead, we scaled back to one extra visit after the child was placed, a more immediate check-in, and then to just go back to those regular review hearings, which are every 90 days anyway. But at those hearings, the court's getting the more information that they've asked for so that they really know what's going on, and to make sure meeting this requirement that residential placement should be limited in time and specific in scope for specific treatment needs. So now the court's getting the information that the court needs to make sure that that is in fact happening, that there's an end date to this, a treatment purpose. Finally, again, I just wanted to bring up the fiscal piece. Again, I know this committee is the policy committee, but you will be voting on the floor on all of this. It is still concerning to us that the three bills that the committee heard today, so SB 459, SB 463, and SB 417, the way initially written, the division was asking for 66 new positions, 46 new CPSWs, 2 new JPPOs, and 18 new attorneys. Currently, there's only 123 CPSWs statewide and 35 attorneys. So you're looking for an ask of an increase of 40 to 50% of their total statewide staff in a non-budget year in 3 bills that really don't require that. So individually, each bill should not require the number of positions being asked. Globally, though, each of these CPSWs do all of these things. This is extremely duplicative then, saying one bill needs 24 new CPSWs, one needs 14 new CPSWs to do a very narrow thing, to increase a visit by 1 hour, to do one extra hearing, to read one extra sentence in the Foster Care Bill of Rights. So we would ask you guys to consider, I know you're not the finance committee, but you are a smart and passionate group of people that care about children. And this is really important policy, and we would hate to see it not go through because there's just so many positions being asked for in a non-budget year. We don't want CCYF to be understaffed. Obviously, we want them to have a reasonable caseload, but right now CPSW's caseloads average about 11 cases, which is very low. They have bandwidth internally, and maybe they do need a few more positions, but certainly not 66 statewide, certainly not individual people for each task being asked for. So we just would ask you to take a look at that, because these are really important policies. And I know we've talked about this a lot, you all know. We did also include the same slide from this morning, just with the number of placements. And the goal here is to keep kids closer to home, in their homes, in their communities, with their siblings. And we know that you all know how important all of that is. So we'll take any questions you may have.
I'm looking at the 2022-2023 LexisNexis in Chapter 169F, and it ends with F4, and then you're picking up here with F8 as if it's new. Is there a whole bunch of court placement laws that snuck in the last year that I'm not up to date on here?
The numbering has gotten pretty tricky between several of our bills. So 1573 adds some F sections. and this bill adds some F sections. So that's
Okay.
something that OLS is going to have to sort out. At this juncture, there's an F5 through 9 between those two bills, and it's gotten a little confusing what's where. So if everything passes, I trust that OLS knows how to count after 4, and
And the
hopefully
le-
they'll just end up where they need to.
And the next LexisNexis will have figured that out.
Let's
Okay,
hope.
good. Thank you. Any other questions? Representative Bickford.
Thank, thank you, Mr. Chairman. I think this is, for the most part, very good, but I do have a section that concerns me, and that's the section 3, where it adds language about the child going back with the other parent, I guess you might want to call it, and then it talks about the court may consider. One of my questions is, do we think our courts don't consider enough? Do we have a problem in that respect? And the other thing I can tell you, I'm very concerned about the parents existing a historical relationship with that child, given that there's constitutional right here to your own child, that would be something to kick them out from being able to take over the care of their child, I guess, because that's the best I can read it. And the other one is a parent's failure to cooperate with the department's assessment. When parents get into these situations, they get pretty panicky. So I'm not surprised that some would become obstinate, you might say, and be considered uncooperative. So those are the two things that really glared at me, and I kind of wish there was a different language, quite frankly.
I appreciate your question. This is a tricky section, and it does raise a lot of those questions. So your first question, currently there's a Supreme Court case called Bill F. So this is typically called the Bill F section for DCYF attorneys, as I was one. The language of that Supreme Court case was extremely limiting and limited what both the division and the court could look at when you're looking at a non-custodial parent in the context. And again, this is not in the context of a parenting case. This is only when the state has taken custody of the child. So they have a case against the custodial parent. The child has likely been removed. They're looking for placement. So the non-custodial parent, typically that parent's not involved at all, which is why there was no filing against them, because they just weren't around. Current law says the division in the court has to find that person has abused or neglected the child, which is very difficult if they've not been involved at all, because they've done nothing. So that was a challenge. So lots of conversations, unfortunately, several tragic child murders in situations very similar, including Harmony Montgomery, but there are others that are not as highly publicized, where the state or court is placing a child with a unknown parent essentially, and didn't have the ability to really fully offer a case. So these new provisions were sort of gathering all the issues we've seen over cases. You've got Boo Vaughn, you have Elijah Lewis trial is coming up. So there's been a lot of cases with child homicides that we saw. The division's hands were a little bit tied. So these are things the court may consider, may being, provisional, trying to list all of the things that we've seen being an issue. The Massachusetts OCA, which I think Cassandra mentioned while I was catching my breath over here, the Massachusetts OCA specifically found in the Harmony Montgomery case that the court should have considered, and we took this language directly from there, the unique needs of the child, Harmony's unique needs, and whether or not the parent, in this case Adam Montgomery, is adequately prepared to address those needs, because they found that he was not, and nobody looked at that, and that child is now dead. So some of these others, the existing relationship, and again, just may consider whether the parent has mental health or substance use issues. And this isn't to permanently keep a child away from a parent. This is to allow the division to offer services to that parent to be able to place. But it must be considered before you put the child there and potentially in danger.
I follow-up. Thank you, Mr. Chairman. Thank you. All right, you used the word non-custodial. In New Hampshire, I believe we rarely do non-custodial anymore. We recognize that both parents have parental rights and responsibilities. And so how does one of those parents fit into this? they're not a non-custodial.
So
They have some degree of custodial right.
in a DCYF case, so again, we're talking about a case where DCYF, so the state already has custody, which means the state has liability for where the state places that child. In a DCYF case, the adults who have the child when the abuse occurs, which can include a step parent, so like the home, they're looking at the home and the adults in the home. The filing is against that home where the abuse happened. There is and the language on the forms is different and frankly not consistent. There's a parent who's not in the home and maybe not accused. Non-custodial was the easiest way to write that. I'm happy if we want to try and find other language, but that's essentially what that means is that parent was not in the household at the time the abuse occurred. And so that parent is not being filed against for that abuse because they were removed from that
It
abuse.
could be merchant marines, it could be working on the power lines.
Likely, they could be. That is not often what I have seen as a DCYF attorney. They're typically just simply not involved in their child's life. They could be living down the street. They could be living on the other side of the country. They didn't have anything to do with that child. So therefore they had nothing to do with that abuse either.
I agree with that. I just don't believe, I want to be careful that we're not wrapping people into with this that shouldn't be wrapped into it.
So
Like I say, there's merchant marines, I have a son-in-law in the Coast Guard.
100%. The division will place the child with that parent if they don't have an issue, if that parent seems adequate. This is in cases where the division has concerns about that parent
See, it
and
doesn't-
needs to investigate.
It just doesn't seem like it reads that way to me anyway.
This section is a specific section, this Bill F section, and it's only when the division has not placed with that other parent. Because there are cases where they remove from one parent for whatever reason and immediately place with the other parent and everything's fine. That parent has the kid.
Okay.
It's cases when the division has concerns about that other parent, that parent can file a motion for a fitness hearing, is what it's called, saying, I want my kid right now. We need to determine fitness. And that's where the problem lies. The current law, the division and the court has very little information to go on, yet it's the state's liability because the state's placing with that person. So it's a very narrow and unique circumstance when this happens. It's not very common.
And it is important to note that the language here is that the court may consider. It's allowing the court to consider these additional factors here, which they currently cannot. But it's not a shall intentionally, because if that parent presents themselves to the court with a longstanding relationship with their child, showing proof of being overseas or something of that sort, the court may not have to consider any of this. There is enough right there for them to go through with it. So it's not a shall, because not every parent is going to need this level of assessment.
Okay, I didn't know the court couldn't look at those things.
Under the current Bill F case, that it's extremely narrow and is challenging, and that is an issue that's been presented to us from both the field and the court. And like I said, mentioned in the Harmony Montgomery case specifically, of we need to allow the court the ability to fully investigate and make sure that the state handing this child over to this parent who wasn't involved is safe, because unfortunately we have a number of children no longer with us because it wasn't safe, but the current Bill F is very narrow.
Well, thank you. Thank you. Thanks for the latitude.
Representative Raymond, I think you had your hand up.
I did, and my first thought was, thank you, Mr. Chairman. My first thought was following up on Representative Bickford's question about what questions is DCYF and the courts asking of those absent parents before they hand over a child. Like in the case of Harmony Montgomery or some of these other children who have been harmed, what's the current practice for when a child is removed from, say, the mother because the mother was abusive and dad hasn't been around? What is DCYF doing now to make sure that dad doesn't have an extreme drinking problem or isn't, selling guns legally or,
DCYF has a limited ability to investigate a parent who is not currently accused. And that's the kind of the rub. It goes both ways of, if you have a parent that's really been completely absent, you know essentially nothing about that person. They've not been involved. And like I said, the current Bill F language is essentially the division has to prove that that person has abused or neglected the child, which if you could prove that they'd abused or neglected the child, you would have filed a petition to begin with.
Right.
It's because this person has been almost completely absent. There's not a lot known. They don't necessarily have to cooperate, that you're stuck in this position of, I can't find this person not fit because the standard's so high, yet I'm handing this child over to someone who may be completely unprepared to parent this child, and this child could be in grave danger.
To clarify, so this language would then allow DCYF and the court to ask those questions?
And to consider it in that fitness hearing and have that be what they're weighing, not this standard of have they abused or neglected, because of course they haven't been around. So it would change the standard to things that actually impact that child's well-being to determine on that. And again, this person still has not been accused of abuse or neglect, but then now the division knows enough to offer services and be able to potentially put services in place and get that child with that parent, but in a safe way.
Can I ask an unrelated
Further,
question?
well, yeah. Follow up with an unrelated question.
Thank you, Mr. Chairman. On a second part of another part of the bill, where it's talking about the preference of out-of-home placement, and talking about trying to avoid residential placement, which I totally agree with. What happens in the circumstances where there isn't a foster home available? Because I think that historically we've had kids going into residential care locally, within the state, because they weren't able to find a foster home that could take all of the siblings, or even that couldn't find a foster home for that age group. Like, what does this bill address that circumstance, and then kind of what happens?
So not directly. It is an issue that we see, and part of the critical piece of this bill is making sure that that's not happening to children, that they're just ending up stuck in residential care when it's not necessary. Because what we see happens now is that there are children filling beds that other children need, and so those children can't get in there because we haven't moved the other ones out. But really the focus here is about the fictive kin or kin foster family, and the division has done some work by working with a new program now that they've brought into the state to do a very thorough kin search for this child. So the caseworkers were doing an initial search, sending out some letters to family members, and that was really all they had the capacity to do. Now that they have a second chance, it is contracted out, and this person's sole role is reaching out to everybody and anybody, checking back with the child, checking back with the parent. Do you know anybody else? Do you have a coach? Is there a teacher? Is there somebody else you're connected to? And because that's their sole role, they are able to spend the time necessary to truly do a thorough search, where the social workers have so much that they're managing that they can't put as much energy into a kin search as what this program can do. And so this would tie into that. Really, the move would be, and we know the research tells us children have the best outcomes when they're in a familiar place, particularly with family are the best outcomes. But even if it's not family, somebody else who's invested in them, knows them, and plans to assist in that reunification when that child goes home. That leads to better outcomes for our children. And so if DCYF is doing that work by bringing the program here, which they've already implemented, and we have this preference of placement in place with kin as that primary, the hope is that they'll begin to be fed into that system at a higher rate than they are. And we've seen it in DHHS numbers. The kin placements have been the ones that are increasing the most, although the residential placements are staying about the same, about that just under 30%, may fluctuate between about 25 and 30%, but the kin placements are going up. So it's showing us that it's working. And so that's why we're looking at now is the prime time to have this, because there are services in place to back that up.
And I would add to that, one of the pieces of HB 1573, maybe we'll get reinstated or not, was an reallocation of funds to recapture funds saved on placing children at these very expensive residential, far out of state, to reinvest in the community resources, because both families, biological families, relative placements, and kin and fictive kin placements all need those community resources to be bulked up. So it is the job of the division to find an appropriate placement, not just a convenient placement. And as we spoke about this morning, children that get placed in residential placement, if there's no real design, like if there's no push to place with a family or a family like setting, they just leave them there because now they're at least in a place. It is also federal law that the lack of foster homes and resources is not a reason to place a child in a more restrictive setting that's not appropriate for that child. So that is also part of federal law, which the division is required to follow.
Representative Panic.
Thank you, Mr. Chairman. Thank you for the reminder as well. Thank you for taking my question. I've got a lot of inquiries from constituents and other legislators. And in Section A on page 2, line 3, the unique needs of the child and whether or not the parent is adequately prepared to address those needs. Could that line just be removed? Because it's just so vague with the word unique. How do you, what is the definition of unique? What do you mean by unique?
So this is the section where Attorney Massio was pointing to the very clear recommendations from the Massachusetts Office of the Child Advocate report in response to Harmony Montgomery. And they highlighted with those specific terms that not only in the state of Massachusetts, but also elsewhere, that the unique needs of the child shall always be considered by the court was their recommendation. And so there's no definition for unique needs, but that is the language that has been captured. And in thinking about Harmony's case specifically, there were medical needs, behavioral needs that were not of a typical child her age. And so given that, parents need more experience or support to be able to manage that, particularly if they're parenting that for the very first time and they don't know that child very well. And so that's what that section is speaking to, is the importance of taking all of those factors into account. And as Lissa had mentioned here, it's also important that this section, it doesn't mean that that parent will never be able to have that child, but it may mean that they meet everything else but understanding their child's unique needs. And maybe there's some work to be done with a service provider that can be put in place to support them in understanding that and how to meet them, making sure that they are effectively doing so before they close out. And then that parent could be the primary caretaker of that child. But do they have the ability to make sure that their child is safe? And for some children, safe means beyond just physical safety. It may mean a child with mental health issues who is suicidal. Is a parent equipped to manage that suicidal ideation on a regular basis? Or do they need some time to be educated to understand that, and then they can take on caring for that child?
And as we've seen, the state is open to liability. There have been multiple lawsuits over these kind of issues because it is the state placing. It's not like, a parenting case where it's just between two parents. This is where the state actually has custody of a child and the state becomes liable then for those placement choices. And unfortunately, the state is getting sued in several cases.
Well, all right, so if you feel that the parent is unable to handle the unique needs of the child, and if we skip over to G, and your agency goes in there and says, we've got to take your child away and place the child in another environment, and the parent is resisting that idea, and I'm going to use an example. Maybe a child wants to transition and is under the age of 18 years old and has had this idea for maybe 3 months, and the parent doesn't think that this may just be a phase, all right, maybe just going through a tomboy phase or whatever, and doesn't want to make a quick decision on something like that. The way this is written, if a parent resists that, it says that this could be this assessment, the department's assessment to provide any records necessary, such a determination shall be weighed as a factor in the fitness of that parent. That's alarming to me.
I appreciate that question. I really appreciate the clarification. So this would not apply to that situation at all.
But if you could change, but I believe what you're saying. So, but I have to go to my constituents and say, don't worry about it. And I know your intentions are good. God bless you for the work that you do. It's not an easy job. Is there a way to reword this that it would make everybody else feel more comfortable with it?
So I would love to give you a simple answer, but the answer is that the section of the law that this is in does not apply to that situation. 169C is only cases where the division is involved. And this particular section only applies if the division, so OCA doesn't provide direct services, that's DCYF. If DCYF has already removed the child from the other parent, so something else happened, this parent did not have that child in their care at all, ever at that point.
You could put in an amendment to say the results of the, maybe put an amendment in there, change the wording a little bit, so it's.
I think
this is raising a lot of alarms with parents.
I totally understand that.
So we need to put that fire out because it's making them nervous. So how do we ease that? We appreciate the work you're doing. I do. See, you're doing it's good work. But how do we put the flames out over here? What can we do to calm that down?
I think the importance with that piece would be education for those parents to understand that abuse or neglect must come first in these instances. And I think what we have heard from feedback directly, separate, from your examples, is that folks in the family court realm are very worried about this. But this would never apply to them. And so I do believe it's education to them to say, this wouldn't apply to you because you're not acting abusively and you're not neglecting your child. It would have to take that first. So given that example of a child who's choosing that they may want to shift their identity at a certain age, they are in a family home, DCYF would have to have a finding of abuse or neglect of that child before becoming involved in this applying. And parents struggling with or not supporting their child's identity and their choice in changing their identity does not rise to the level of abuse or neglect by the current statute that we have, nor any proposed changes to any abuse and neglect laws is the intent of any of that to add to that a parent not supporting their child transitioning. Now, we do understand that transitioning can lead to things like suicidal ideation. So if, again, after the abuse and neglect already occurs and a parent is coming in and that child had already been removed from that primary parent and the other parents to take them and they're meeting them for the first time and the child's saying, I don't want to be called Sally anymore, I want you to call me Johnny, and that other parent is saying, I don't know about this, I don't feel comfortable. The court can look at that and say, are you meeting your child's unique needs? Are you open to the conversation? Are you abusing your child because of it? Are you putting them down because of it? Or are you telling them, I don't understand that concept. I don't necessarily support that concept, but you can take the time to figure out your identity. You can talk to other folks, but you can do what you need to process that, but I don't understand and accept that. That's not me. That's not the level of abuse or neglect. Now, if that child then says, well, my parent doesn't support me and now I'm suicidal, and that parent says, well, you're suicidal, too bad, you're on your own. Now we're talking at the point where it could be getting to a level of neglect. Now, if that parent says, you're suicidal because you have an identity crisis that I can't support you in, but I'll bring you to the hospital and make sure that you get treatment so that your suicidal ideation is addressed, well, then that parent is taking the appropriate steps to have their child's needs met. So they are still doing that. So that's where I think the education piece and talking about it more is really helpful, because I truly agree with Attorney Mascio here that I do not believe that the folks you are hearing from would be involved in these hearings at any time. They clearly are invested in their children's lives and have that custody. So it would not impact them. But there could be future education, and we are happy to have these conversations with folks to ease their worries. That is not a target at them.
All right, the chair's going to jump in here with a real concern. I have 7 more pink cards.
Yes.
We have to exec 2 of these bills, including this one. So I'm going to put a restriction order on everyone now to testify for 3 minutes. I'm also going to ask the committee here, if you don't need to ask the question, don't ask the question, simply because we have no other options. I'm quite prepared to stay here till 10 o'clock at night, but I don't think I'll have a quorum at that point. So, okay? Thank you for your testimony.
Thank you.
That popcorn offer is still good. And when we go to watch that video you've promised us too. All right, Chair recognizes Holly Stevens from NAMI, and I know you've got some handouts, and would ask you to, you want to speak for 3 to 5 minutes. God bless you for that. We'll hold you to it. You've always been very good at saying a lot in a few minutes.
Chair Pearson, members of the committee, my name is Holly Stevens. I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance of Mental Illness. I will spare you the description of NAMI. It's in my written testimony, and I'm sure you know it by now. Just a couple of things. You've heard a lot about this bill, so I just want to point out that research has found that compared with siblings who remained at home, children placed out of the home had increased risks of violence, antisocial behavior, low education, common psychiatric disorders, depression, or premature mortality, either by suicide or injury in adulthood. And it further found that a foster home is better than an institution, and that having only a one and only stable placement is important for child stability and well-being into adulthood. You've heard about what this bill does, so I will not, I will spare you that as well. But we do know that children have much better developmental and mental health outcomes when treatment is provided as close to the family and community of origin as possible, and where the family connections can be preserved, and you've heard that this bill would do that. Additionally, as referenced above, children experience better health and social outcomes when out-of-home placements are not in institutional settings, but are in things like foster homes. So Senate Bill 417 promotes better mental health outcomes for New Hampshire's youth requiring out-of-home placements. And for those reasons, NAMI New Hampshire urges that you support this bill.
Wow, thank you. Any questions?
Chairman?
Yes, Representative McMahon.
Thank you, Mr. Chairman. To take the best advantage of your guidance, so the wording that's in the bill now would meet the vision that you just espoused?
Yes. As you heard from the Office of Child Advocate, it goes through the order of placement, and the order of placement would support children's mental health.
Thank you, Ms. Stevens. Thank you, Mr. Chairman.
Anyone else? Thank you so much.
Thank you.
Chair recognizes Karen Rosenberg. I don't want to pass over you.
Funny guy.
Good afternoon. Thank you. I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center, and I'm here on behalf of the Disability Rights Center and also in strong support of this bill, and also here for the Juvenile Reform Policy Group, which, as you know, includes New Hampshire Legal Assistance, Waypoint, New Futures, and the Children's Law Center of New Hampshire, also strongly supporting this bill. And it won't take a lot of your time. I think it's really important to keep in mind that all of these children that we're talking about who are court involved, whether they are in the juvenile justice system, they're in the abuse and neglect system, they are in CHINS, Most of them have mental illness of some sort or some other kind of behavioral challenges, and 100% of them are going to be coming home at some point. And where is home? And how are they going to have the most successful reentries to their homes? Well, if we can avoid reentry by keeping them in their homes, that's the gold standard. If we can put services into place that will keep families strong and keep families together, that's really what we should be aiming for, and that's what this bill would require. And it also, the other thing that's really important about 417 is that it creates an order of preference, recognizing, again, the children are going to do better when they can maintain connections with, whether it's with their biological or adoptive families, their friends. I mean, think about teenagers. Who do they care about? Their friends. They're not going to school to learn Shakespeare. They need to be with the communities and the people and the leaders in their communities that are going to be those mentors and people that are going to be important to them while they're court involved and also when they're no longer court involved. So the order of preference is super important to my organization as well as to the rest of the JRPG. And oversight is also really important for those instances when children's needs cannot be met in their homes or in a foster home, when there's no fictive kin or people in their lives who can take them at these terrible junctures in their lives. We want to make sure that they're safe and that there's adequate on-site, eyes-on oversight, and that courts are thoroughly considering what the children's needs are, and that we're not keeping kids, even kids who need a brief therapeutic placement, that they're not being kept too long, because then there's diminishing returns and they're not going to benefit from that treatment. So for all of those reasons, I encourage you to support SB 417, and I'm happy to take any questions and understand you've been here for a long time if you don't want to.
Any other questions? Thank you so much.
Thanks.
We've had an adventure today, several of us, haven't we? Rebecca Ross, Attorney Ross. You are not Attorney Ross. I know Attorney Ross. Attorney Ross is a friend of mine. You are not Attorney Ross. Oh, there we are.
I'm not a friend?
That was a quote from a Texas senator about JFK. But, and yeah, thank you. You caught that. Thank you. Those of us who are older.
So Rebecca was here because, as you all know, we've been all playing musical chairs this afternoon to try to get here between Judiciary and this committee. So I'll introduce myself. My name is Krista Morris. I'm the Director of Intergovernmental Affairs with DHHS. And with me is Attorney Ross.
Rebecca Ross, Director of the Bureau for Children's Behavioral Health.
So we're just here to support SB 417 as it stands. Specifically, you know, we have worked with the OCA on many iterations of this to try to bring it to a place that we can all agree to. And specifically, Section 6 just requires that DCYF expand their monthly visits to youth who are in placement. And with that includes a broader tour of the facility, as well as discussions with providers outside of the monthly care coordination meetings. Staff make attempts to have those discussions with those providers in person, but we appreciate the flexibility within SB 417 to allow some of those visits to occur real time, virtually over the phone as needed. Sometimes things happen and our staff can't track down those staff members, whether it be vacation or something like that. I do want to address, however, some of the items that have come up in today's discussion. I was running back, so I only caught half of, I believe, the OCA's statements. One of which is addressing the staffing request on behalf of DHHS. The way fiscal notes work is that we have to look at each bill individually in a vacuum, four corners of that document. We can't take into account other bills that are going through the process. So with that, that's why it looks like it is a bundling or a larger number of staff. Could there be overlap of some of these responsibilities? Possibly, but we cannot take that into account when we draft our fiscal notes. And so that was a large number, I will admit. However, to make a statement saying that we are asking for 66 staff total, obviously that would have to be readdressed should all of those bills with all of those parameters pass. One item of note also was increasing the hearings. Yes, we do require more staff as we increase the number of hearings. part of that is it's not just one extra hearing. It is with each additional hearing comes an extra day of staff preparation. It takes a full day for staff to prep for a hearing. And then on top of that, an additional day for them to sit at the courthouse almost all day waiting for that hearing to come up. So unfortunately, that's an additional 2 days per child per hearing. Again, the staff doesn't mind doing that, especially if it's prescribed in law, but rather to say that it doesn't take more time is not accurate. Our staff has gone over this with me quite a bit. I've learned more about the court system than I probably care to know about.
You can go to law school with me.
And lastly, one thing I do want to bring up is the caseload, and I know it's a kind of a side quest, a side topic. However, as we talked about caseload for staff, yes, we have 11 cases per staff. Sorry, I'm pulling up an email that addresses some of this. It is actually national policy, and I would say it is, now I can't think of the name of the organization. However, that we not look at caseload or the number of cases, but rather the workload. So as these cases are more difficult, they are more complex, fewer cases is actually better because of the fact that they have larger needs to meet within each case. So 11 cases, but they could take twice as long as your average case elsewhere within the system. So we just want to address that as well. We have a low caseload, and that was part of the previous DCYF administration to bring that caseload down so that we don't create burnout, we don't create high turnover, we don't lose valuable staff to the department. And in order to do that, we have to keep their workload at a reasonable, manageable level. So that's all I have. If you have any questions.
A recent redo of the needs of the judicial system were based not on cases, but actual real time. It's a fascinating
Workload. Yeah.
read. When you're done reading LexisNexis, that may be the thing you want to go to after that. Any questions? Representative Raymond.
Thank you, Mr. Chairman. I just wanted to follow up on the staffing requirements of the bills, because even as I looked at this one, I thought, I mean, it's good that we're going to have the same caseworkers visiting the same kids instead of having this like shuffling thing. But 8 seemed like a lot to me for the 7 kids we have out of state right now. So can you give us an idea of total, say we pass all 3 bills, how many staff do you like realistically need? It can be a range if all 3 bills change with their individual new requirements.
I would not be able to give that to you off the top of my head. That would have to, that would take probably about a week's worth of review for the staff to come up with.
Okay. So, but
oh, sorry.
That's okay.
I was going to say, and it really depends on the nuances of each of the bills, but it's not just the 7 youth that are currently placed outside of New England. It's the 12 additional visits for each worker to all of the New England programs. And so when you're adding that up, it really is looking at, we may have had somebody from the Lancaster office visit, or North Country office visit a youth in a Lancaster program, that now we're having the worker from Salem driving up to Lancaster 11 more times, or however many more times. So I think the travel time can be equal across New Hampshire as it can be for some of our national programs.
Yeah, that's fair. Okay, thank you.
Seeing no further questions, thank you so much. Chair recognizes Mr. Joseph, is it Noon, sir? And we are going to put you on a, like we have with the others, 3 minutes because of a massive time crunch we're under.
All right, thank you. I am Joseph Noon from Henniker. Everything I am about to say is the truth and nothing but the truth, so help me God. This bill should be opposed. First off, this, Part 3G, parents' failure to cooperate with the rules of assessment or provide records shall be weighed as factor in the fitness of that parent I see this as a direct violation of your right to remain silent or your right not to furnish evidence against yourself. Specifically, a direct violation of the New Hampshire Constitution, Article 2, Part B. An individual's right to be free from intrusion in private or personal information is natural, essential, and inherent. There's also other provisions within the Constitution, New Hampshire Constitution, that are very similar to the Fifth Amendment of the Federal Bill of Rights. You have a right not to furnish evidence against yourself or testify against yourself. Furthermore, we have Part D, where it says, gives terms like educational needs, medical needs, health care. These are vague. These need to be defined. Educational needs could be twisted and turned around by these guys simply as you didn't fill out this magical paperwork and you're homeschooling your children. Medical needs could be, oh, you didn't affirm their gender. You didn't get them some kind of vaccine that doesn't have a double-blind placebo safety test to it, or this healthcare stuff. Also, I would like to say that social workers lie. I have evidence of them lying. In fact, I have some court documents that I'm going to give you guys here in a second. I didn't make multiple copies. I didn't have the ability to do that. But I was involved with a DCYF situation where a social worker presented a assessment order to us from family court. I rejected that particular social worker's offer to contract with me because it's all DCYF is doing is offering to contract a service. They talk about giving you these services, but they threaten you. I was threatened by the social worker, said if I did not comply with the assessment order, it would be used against me, and they would bring a contempt order against me. So I did some research on New Hampshire DCYF. I did an internet search of the term NHDCYF settlements. Hundreds of millions of dollars of settlements have been settled by the Division of Risk and Benefit based on rights violations done to people by New Hampshire DCYF. Furthermore, I agreed to have this order, this assessment done by the police, the Henniker Police Department. The order doesn't order a parent, doesn't name me or my wife. It just says a police officer or child protection service worker or a child protection service probation officer shall interview a 2-year-old child and enter premises in my particular case. What I have here to give you guys is I have a narrative from the Henniker Chief of Police about this situation, about the social workers lying. Also, these social workers do not have oaths of office, and they are protected by RSA 99 qualified immunity. I have a copy of a letter here that I received due to a right to know request asking for bonding information and oath of office of social workers. They do not have them. That being said, the assessment was, I complied with the assessment by asking a police officer, guy's name's Matt French, Chief of Police of Henniker PD, to do this assessment, to interview my 2-year-old daughter alone, and to inspect my house. When he went back to DCYF, they said, no, you can't do this, you're not qualified. But also, DCYF doesn't get the Title IV money, incentive money from the Social Security Administration unless DCYF does the assessment. From what I understand, it's like a $6,000 payout to DCYF. If the police do it, they don't get the money. And the social workers are trained in a program at Southern New Hampshire University called Maximizing Revenue for DCYF, how to maximize all this revenue for DCYF. Furthermore, after I told the Henniker Chief of Police I would allow him to do the assessment, and the multiple social workers and lawyers, Ross McLeod, the lawyer, social worker Melissa Coombs, and supervisors at DCYF were hell-bent on him not doing the assessment, him and his officer. You can read about it in the affidavit that he filed in family court that I'm going to give you here as part of these documents. The social worker, Melissa Coombs, and Ross McLeod escalated this situation by filing a contempt order after I had asked that the police do this assessment, which the original assessment order says they can do. And also, you'll see if you go, your stomach will get turned when you internet search New Hampshire DCYF settlements and start reading all of the newspaper articles and everything written in it about what's going on. And the taxpayers are just forking out hundreds of millions of dollars, quite literally, and this is going to continue as long as DCYF exists and is operating without due process of law and is operating in family court, which is not a court of record. All of this stuff is unconstitutional, and the people are waking up. They are learning about this stuff.
Sir, we're going to have to ask you to wrap it up. I gave you 3 minutes, but I got so intrigued with what you were saying. It's way over 3. Could I give you 1 more minute, please?
Thank you. So I oppose this bill. I oppose that the parents exercising their constitutionally secured rights to not incriminate themselves being used against them. I oppose family court operating without due process of law, and I oppose this on the behalf of the people of New Hampshire, because the liabilities are going to increase if you give social workers any more power. And if you hire more social workers, there will be more lawsuits and more liabilities. This is quite massive, and thank you for your time.
Thank you, sir. Appreciate that. You got a lot in, not too much time. Thank you. Chair now recognizes Emma Savini from New Futures. And you've got some handouts. If that's one stack, is that one stack, Representative Panic?
It's, yeah, in one individual copy. I didn't.
Okay, it's one stack. That should go to the clerk. This clerk, yeah. Or Emma Savini, there you are. Hi.
Hello, thank you for having me this morning, or I guess it's
It just
afternoon.
seems that way.
Afternoon. I've been here all day. Thank you, Representative Pearson, Chairperson Pearson, and honorable members of the committee. For the record, my name is Emma Savini. I am the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonpartisan, nonprofit organization that solves problems through policy change. We are dedicated to supporting and strengthening a comprehensive and integrated system of care for children's mental health. We are here in strong support of Senate Bill 417 because it aligns the child protection statute with the system of care values, such that the children who are involved in both systems would have better mental health outcomes. RSA 135 established the system of care and put a heavy emphasis on community-based and evidence-based practices because when children have treatment in their communities, they have better mental health outcomes, and when they use evidence-based practices, they also have better mental health outcomes. Senate Bill 417 integrates those principles into the child protection statute by encouraging families to stay together in that order of placements that everybody's been talking about today. It highlights the importance of keeping a family together in the first instance and only looking outside of the family when it's absolutely necessary for the safety of the child. And then after that, going to kin or fictive kin, and then a home-like foster care setting where, again, children have better mental health outcomes. We know that when kids are placed with kin, they have fewer changes in placement over time and have better behavioral health outcomes, fewer behavioral health, behavioral issues. It's also nice to have kids in their communities. When kids are placed within their communities, they don't have to change schools. There's continuity of care with their providers that they already have established, and they have better mental health outcomes because they have the support and love of family and relatives nearby who can also participate when appropriate in therapy with the child. And I go into more depth in my testimony, but for those reasons, we urge you to support Senate Bill 417 as amended, and I'm happy to take any questions.
Seeing none, thank you so much.
Thank you.
Chair recognizes Attorney Erin Cregan, hiding in the back. There she is. That's a comfortable seat. I camp out there sometimes.
Good afternoon, Mr. Chairman, members of committee. Erin Cregan, General Counsel for the Judicial Branch. Continuing my streak of being the least interesting of your witnesses and only giving you technical and implementation feedback that the courts may have seeking your guidance with the bill. I would like to say, I know that you don't have a lot of time, that we've had a lot of collaboration with the OCA, with others, with DHHS, and we've appreciated all the work that everyone has done already to meet some of these questions. Just two that I leave you with. One is on page 2 at line 24 and page 4 at line 4. There's some language, presume that remaining in the family home is in the best interest of the child. Under RSA 169-C:19-H, that standard should be contrary to the welfare of the child, unless you intend to change the standard, which I think it is not intended to be changed. So I would recommend, if that's not your intention, to harmonize that standard.
Might I suggest, we're going to exec this bill in about 20 minutes. We have no choice. So if there's something that really should be changed, there's this group called Finance. And they change things.
I have met them.
You've met them before. They like to change things. So pass that on to them with my love.
Certainly will.
Okay.
And the only other thing I'd like to just mention, because it's a little bit of a policy direction that you, the policy committee, might like to give, is in about 3 places there's a reference to neither the shortage or lack of foster family homes nor the lack of community-based resources shall be acceptable reasons for determining that the needs of the child cannot be met in a family setting. I've run that language by a couple judges just to see if they thought there was an implementation challenge there. And I think there's a little bit of confusion about whether this is a directive from the policy committee not to place a child in residential care, even if that is the only option. This is a scenario that can come up. The language suggests that if it's not in the best interest of the child, if that's not the best setting, that's potentially prohibitive. If that's not your intention, would just appreciate a little bit of a clarification.
Well, having learned how to think like a lawyer, I really could see that that's a squiffy statement, and it needs to be clarified. And so Finance will do that.
All right. Thank you, Mr. Chairman. Appreciate the time.
Anything else? Anyone? Okay.
Thank you.
Thank you. And this concludes the hearing on Senate Bill 417. Now, let's take about a minute to breathe, and we will open a exec session on 463 very simply because it's likely to be easy. We're going to either like the amendment proposed or not, and then we can like the bill or not. Shouldn't take too long, so let's take about a minute, minute and a half. To the committee, there's an amendment coming around. Please take this opportunity to read it. We'll start the exec session in a couple of minutes. Just read it when you get it. Opening the executive session on Senate Bill 417, we start with looking at an amendment, and you should have Amendment 2024-1587H in front of you. And this is in response to conversations with numbers of you from both parties and a whole slew of emails that a number of us have gotten. Lines 1 to 11 are not changing anything. It's what's already there. OLS sometimes likes to give you a running start into where the changes are. What is the operative thing has to do with line 16 to 23. Representative Panic articulated what a number of people have been saying, and the wording in the original bill, the unique needs of the child and whether or not the parent is adequately prepared to address those needs, is stricken in the amendment. And while some have argued that this is a child who wishes to be transgender and the parents don't, and therefore the child is dropping a dime on the parents, they're not meeting my needs, this could go the other way too. And I am familiar with a case in an extremely red state with a child dressed as a Nazi, gave Nazi salutes, and went to websites, and the parents said no. And then the child said, "You're not meeting my needs." So this isn't a right versus left, left versus right. This is the language is way too broad. That isn't to say other language could not be added at some point in the future. But I know way too many people who would not vote for this bill because of that line item. So this amendment, first of all, takes that out. Secondly, and you heard the testimony from the gentleman on what has been number G originally, it's now F, but it continued a parent's failure to cooperate with the department's assessment or to provide any records necessary, ... shall be weighed as a factor in the fitness of that parent. That's a threat. And while, of course, if there's a preponderance of evidence that you are harassing and not cooperating and running people off your land and all of that, of course that's going to be taken into account. But to put it specifically in here sounds to me like the literature I sometimes get from certain people in my party. We're watching how you vote and we will take action accordingly. I don't need to hear that. I don't like to hear that. So in the amendment, it's F, which is the first half of the old G. So those are the two things that Representative Panic spoke to, and a number of you and I have spoken on. The second part of the amendment has to do with fictive kin. And if you turn over to page 2, it is line 4, Roman 3. There is no definition in statute on fictive kin. The clerk did some research for me. Ms. Dyer did some research for me. There's language about kin, and it is inferred, or it may be inferred it means fictive kin, but it doesn't say it. A national organization of legislators, and some of us had lunch today with somebody, well, and we all heard from NCSL, got together a group of people like us and came up with a definition of fictive kin. And it reads as it says here. And although I'm not a lawyer yet, I know that if a term is used in law and it's not defined, you have a problem. So here is a definition for fictive kin. So what this amendment does, Amendment 1587, is it addresses two issues. One is a couple of lines having to do with what are the determinatives, and then secondly, the definition of fictive kin. And my vice chair says that he certainly has no difficulty with this himself, so it sounds this could be bipartisan. So before I move it, I just wanted to sense reaction, because I have a couple of other amendments I could put in if somehow this one doesn't make it. Yes, Representative Nelson.
Thank you, Mr. Chairman. I do have one question. If you could please enlighten us on line 6. A parent who has not been charged with abuse or neglect shall be afforded upon request a full hearing in the district or family court was stricken and circuit court was inserted.
That is not my doing. That is the bill before us. And as I said at the beginning of my presentation, sometimes OLS likes to get us into the language that is already there in the bill that is not being amended. So,
I think it's a mistake.
yeah, go.
But in the bill, it doesn't. In this bill that we're seeing, it's not in that bill. In the bill, it states full hearing in the district or family court regarding his or her ability to obtain custody.
Huh. You are correct, but I think circuit is the correct term. So thank you for that. You had that correct. Then again, there's always Attorney Cregan when you need one.
Sorry, just wanted to mention that because the legislature consolidated the family court and the district court as divisions now of the circuit court, whenever we open up a statute, we generally try to fix that anywhere, but it is certainly not pivotal, but it is just more accurate at this moment.
We'll take that win. Thank you. Any time, really. Okay, yes, follow up.
Follow up. Thank you. I thought that was my understanding, but I always like to have clarification. So thank you for
making this necessary. Yes, Representative Raymond.
Thank you, Mr. Chairman. I do have a question about striking the unique needs of the child, because when I read it, honestly, transgender issues never even popped into my head. When I read unique needs of the child, I was thinking about a child who was deaf or blind or had some other serious medical condition. Perhaps they're in a wheelchair. I've worked with kids with cerebral palsy or muscular dystrophy or other unique needs that would require specific assistance to a parent who has never parented a child with those needs. Anything about gender, none of that ever occurred to me. So my concern is, by striking that, are we now eliminating the ability of a parent who has never parented a child with these types of needs from being able to access services and help through the court system? Or from considering their ability to ramp up on those needs before placing the kid with them.
I wouldn't think so, no.
Okay. So, I mean, that's my concern. I would hate to see a situation where we take a child who, for example, is deaf and put them with a parent who doesn't know any sign language without considering what the impact of that would be. I think they should be with that parent. I just think that there should be services.
Yeah, I can't see that scenario taking place. Plus, this language, by the way, is also in statute presently.
What language?
I believe the language of the unique needs of the child. I
No,
was
it's
told that.
It's not. It was
It is not?
It came from Massachusetts statute, which is why they were trying to add it to the New Hampshire
see.
statute. And again, I think it was designed specifically for kids with developmental delays or other, medical or mental health issues that are not developmentally, not part of a normal developmental stage. So I'm like super worried about us ending up in a situation again, like the Harmony Montgomery case and the other child whose dad poured boiling water on him, where the parent is not prepared for the needs to meet the medical or emotional or behavioral needs of that child without help. Because it's just so stressful. It's stressful to be in that when you have all the services. I can't imagine how stressful it is if you've never experienced it before.
Representative Ball.
Thank you, Chairman Pearson. I would think that then it would go to that next one where it says they're going to look at the existing and historical relationship. So if there was no historical relationship, by virtue, the parent may not know how to work with those unique needs. But if they have had that involvement, that's looking at the whole child.
Anyone else? Yes, Representative Perez.
Yeah, I just want to say, hopefully before we decided to vote for this bill, we do care and pay attention to that we are here to protect the kids. Yes, I do care about the parents, but to be honest, as a survivor, I do care what's happening to the kids and what are we doing to protect them, to make sure that, the things that we see and happening lately is not happening again.
The welfare of the child is the primary factor to be weighed when determining if a parent is fit to protect the child. That's part of the language in this amendment. All right, I am going to, we have opened the hearing. I am going to move Amendment 2024-1587. Do I have a second? Second from Representative DeSimone. Any further discussion on the amendment? Seeing none, when the clerk is ready, please call the roll.
Chairman Pearson.
Yes.
Representative DeSimone.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball. Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Petrina will vote yes. Representative Perez.
Yes.
Representative Gregg.
No.
Representative Raymond.
No.
Okay, motion passes. 1, 2, 3, 4, 6, 7, 8, 9 to 2.
9-2, and we do still have our quorum. Now let me find what I'm looking for. Yeah, I know that. I'm looking for my cover sheet here, which is gone astray. Okay. Chair will entertain a motion on the bill as amended. An OTP motion. You get to write the blurb. Oh, if I write the blurb, if I write the blurb, I make the motion. I'll have to do it. All right, the chair will move the bill as amended. So that's Pearson. Could I have a Democrat for the second? Democrat who voted for this? I appreciate Representative Petrino. Thank you. All right, so the motion before us is Senate Bill 417 FN as amended by 2024-1587H. Motion made by Pearson and seconded by Petrino. Would a clerk please call the roll?
Chairman Pearson.
Yes.
Representative DeSimone.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Petrino will vote yes. Representative Perez. Representative Perez.
Yes.
Representative Gregg.
Regretfully, since it's been amended, but yes.
Representative, Representative Raymond.
Yes.
Okay, motion carries 11-0.
11-0, and I will write the committee report on that, and it goes on to finance. And this will conclude the executive session on Senate Bill 417 FN. And I now open the exec session on Senate Bill 463, expanding access to court-appointed counsel. And you may remember Senator Carson. There was a question before us that what if the judiciary, even a year from now, does still not have enough judges to be able to assign a judge to a person of tender age needing such? And so since this was anticipated as being an issue, I have an amendment which would take out some language and change things to say, if no attorney is available, the court may proceed without appointing an attorney for the child. It is aspirational, and I'm sure the court is working towards it, but what if when the bill takes effect in July of next year, there still are not enough judges? The amendment to consider is that sentence: if no attorney is available, the court may do such and such. And you are asking actually to see hard copy, aren't you? And so here's the amendment coming around. The language in question is lines 6, 7, and 8. And down in line 24, the word guaranteed is removed. And it simply reads now the right to an attorney, not the guaranteed right to attorney. So this is ready for your thoughts. So once again, this is the only change that the amendment makes is lines 6 and 7. If no attorney is available, the court may proceed without appointing an attorney in the field. And line 24 takes out the word guaranteed, where it used to say the guaranteed right to an attorney. Now it says the right to an attorney. So that is the difference on the amendment. Mhm. Okay. Would somebody care to make a motion? Representative DeSimone?
Thank you, Mr. Chairman. I'll make a motion.
Mr.
on
Chair?
ought to pass on.
Hold off for a second. Yes?
On the amendment, on line 7, well, at the end of 6 and 7, it says if no attorney is available, the court may proceed without appointing an attorney for the child. I'm not seeing that in the original bill.
It's not. That's why this is the
That's
amendment.
the amendment.
That, they put it in the bill. It's not in the bill.
Yeah, they put
They put it, okay, thank you so much. That's like,
That's okay. Please. Makes me feel good when people are tired also. Yes, Representative DeSimone, start again, please.
Thank you, Mr. Chairman. I will still make a motion of ought to pass on Amendment 2024-1578H.
Moved by Representative DeSimone. Any second? Do I have a second? Representative Nelson. Any further discussion? Representative Raymond.
Thank you, Mr. Chairman. So my question is about the new language. So it says the court may proceed without appointing an attorney for the child. So I'm envisioning a situation where there is an attorney immediately available. We move forward. What happens at the next hearing? Is this that child never gets an attorney, or at what point now can the child get an attorney?
Well, reading the language as a liberal arts guy, you can proceed. I would assume that when an attorney is available, that attorney is appointed. But you're only proceeding when there isn't one available. That would be my guess. How would judiciary understand that?
Right, I just want to make sure that we don't lose a trigger point.
Oh, I appreciate that.
For
Thank you.
appointing an attorney.
Thank you, ma'am. I appreciate the question. I read it the same way, which is proceeding is only while you're proceeding that the attorney is not available. There's always the discretion to appoint an attorney under this language. It's been added that the court always can as well. So if they learn that there's one available, they can appoint them at any time. But I think it's certainly complicated as you get pretty far in the proceeding if an attorney hasn't been available to the very end, that there may be some challenge there. But the court has the discretion to add an attorney later if one becomes available under this language.
Does that answer your question, Representative?
It does. Thank you.
You're welcome. So another hand, Representative Gregg.
Thank you, Mr. Chairman. So we had a much more robust conversation about this one on HB 535 on our very own bill that went out. And I think that, one of the things we talked about is that the amendment just basically took this bill, out at the knees that we left in at on our particular bill is giving it an out for them not to be able to get, we talked about in that executive session that we wanted to force the issue that they be able to get an attorney. Instead, we're just saying, well, but if there's not, then, go ahead and move on. I think that necessity sometimes dictates stronger action. I think that we have had very big discussions in this particular room about the necessity for children to have this. And I worry that we took any power away with this amendment. I do not like this amendment.
Anyone else? It goes to the old question of, do we lead with carrots or sticks? And I can see the need for both. And, as a carrot kind of a guy, generally, I let people know I also know where the sticks are kept. And one could argue if one argued, and I'm neutral. I just brought this in because some people wanted it. I really don't yet know how I'm going to vote on this, and I got to know that pretty soon. But I could argue from the carrot point of view that this is highly aspirational. Judiciary knows this is what we want, judiciary, and if we don't sense that there's good faith forward progress being made, next year we come with a stick. We could say that. As a carrot guy, I don't mind saying that. We could also say, my gosh, the thing isn't going to kick in for what, a year, is it? This bill isn't going to kick in for a year, and yeah. So, I mean, golly, there are lawyers who might want to be found within a year, that we could argue it that way. So I'm just putting the amendment out, and I can see both sides of this. But thank you for your point. Anyone else want to weigh in? You like the bill and you like the amendment. So the last person I said, are you ambivalent to, said, well, yes and no. Go ahead. Yes.
Thank you, Mr. Chairman. I can see everybody's point. My fear without the amendment is that a proceeding would be held up and a child's issues in the court would not proceed because there is not an attorney available. And I would hate to see a child's issues not be addressed as soon as possible. That's the reason I like the amendment.
Anyone else? Representative Gregg for the kill.
Sorry, just and on that flip side, I mean, I think that I obviously see the argument on both sides. We rush a child into something and they end up in a situation where they're in a lot of danger, and that does a lot of stuff. So there are points on either side. It's just, you know, why have bills like this? We really had a great discussion on our own House bill and decided that it was ready to move. So why we're not moving in the same way with this one, I'm just a little confused. But I do see that. But the rush to say, okay, well, we can't get an attorney, so we're going to give you half the amount of care you should have. And, you know, we're going to rush you into a situation that maybe isn't the best for you because you don't have somebody to advocate for you. These kiddos are not coming that are, you know, going to be able to articulate well, that even have a lot of insight into their situation. You know, it's important to have somebody there for them representing them.
That's wonderful. Anybody else? Representative Ball.
Thank you, Chairman Pearson. So I'll just ask the question just for clarification. Further down, it says that they have the right to the attorney, so wouldn't they be able to say they don't want to proceed without an attorney?
The change on line 24 is the removal of the word, the guaranteed right. Meaning, let's say you have a right to do it. And if we had one, we'd get it to you. Guaranteed right means you are going to have one.
Right, but I'm saying, but this goes along with if it's not available, but when you still have the right to say, I'd prefer to hold off until there is a attorney.
Would a
available.
child be wise enough to say that?
Well, some of the older ones, are they in their Bill of Rights? I don't know, I'm just throwing it out there as the devil's advocate, that
I agree.
isn't there a way to stop, you know, that we don't?
Mr. Chairman.
Representative DeSimone.
Thank you, Mr. Chairman. I think what Representative Ball is pointing out is further down in the Bill of Rights. Roman numeral, was it 14A, says
Of the original bill?
no, in this amendment.
In the
I'm
amendment,
reading it.
okay.
On line 23, it says they have the right to be informed of the right to request an attorney under RSA 169C10, Roman 2, lowercase a, and of the right to an attorney under blah, blah, blah,
Blah, yeah.
in certain circumstances. The department shall provide the child with a written statement of these rights and process by which to request an attorney. So if the child we were talking about was before the court and there was no attorney available at that time, the child can still request an attorney. And at that point, my guess is, and we can ask judiciary, that the proceedings would then cease until an attorney was available.
Attorney Cregan, that's
Is that
a
true?
question that is not policy, it's procedure in judiciary.
Would that be true, that the proceedings would cease until an attorney could be? In the amendment on line 23?
Amendment. Are you looking at the amendment of the original bill?
No, sorry, I'm looking at the original bill just to try to put it in a context. I'm not certain if the proceedings would entirely cease. There could be a delay as they try to locate someone, but I think there's still statutory timelines for some of the underlying proceedings, so it's not a complete halt, but certainly to try to address the request.
That answer your question?
Yes, it does.
Okay, good, thank you. Anybody else? Very good tie. Representative Seidel.
So on the original bill, now I'm all discombobulated.
Sorry, can't hear you over the background chatter. Go ahead.
On the original bill, and I was looking through something else and now I've lost it.
Thank you.
Actually, we'll go to the amendment for line 24, where it's talking about the guaranteed removed rights.
Yeah.
In certain circumstances was added that was not in the bill. What certain circumstances would that mean that a child has got the right to an attorney?
I did not ask for that to be added.
No, that's in the original statute.
Oh, okay, all right.
No, that's in certain circumstances are right here on this
Okay. Yep.
amendment. Oh, that's in the original statute, you're saying?
Yeah.
Okay.
All right, let me look
But
it up
wasn't
in
the
LexisNexis.
bill. Where did that go? Right here. Where I left my pen.
Representative Seidel, the amendment encompasses from lines 3 through line 16.
Okay. (169C10 2B) is new within the last year or two.
Yeah, it is. But it's already there.
But it is there. I don't know. Does anybody have a newer addition to 169C10 than my LexisNexis has? Because it is not in my 2022-23 LexisNexis. Oh, it could be over there. Why do we have all these law books? Yeah, it's 169-C:10, comma, Roman 2, parenthesis, lowercase b. Amazing. I got this wonderful gift and now it's out of date. It's this. It would have to be.
Mr. Chairman, would you like me to read what it says on the internet?
We're going to read along with you here.
All right.
169-C10. Those are additions. So go back to the. Yeah, hold that want to read for just a sec, would you please? Yeah, because it's not in the 2022-3 edition. So C10, Roman 2. B, in certain circumstances. C, 2. All right, the person who volunteered to read what's there, would you read it, please? Thank you, Ms. Dyer.
So the internet says under RSA 169C10-2B. When an attorney is appointed as counsel for a child, representation may include counsel and investigative, expert, and other services, including process to compel the attendance of witnesses as may be necessary to protect the rights of the child.
That unpacks
Yeah,
the,
but that's from 2022.
well, fine.
Effective. Yeah.
I
That's
don't,
the most recent one that. Oh wait, it says there's a new. Let's look at the newer version.
yeah, because Lexis doesn't have it.
The newer version. 2023. View our newest version here. No.
Does it say on the top of yours, Representative Raymond, current chapter 7 of the, current through chapter 7 of the 2024 legislative session?
No.
But I read what you were reading is exactly word for word what I have.
Right.
The newer version you're saying doesn't have it?
Nope. The only other things I can find, Mr. Chairman, are the proposed bills for this session.
Are we gonna stay stuck on the unpacking of certain circumstances? I would like to proceed one way or the other with the amendment because the guts of the amendment is whether or not the lawyer for the child must be done, or we're really going to try hard to do it, but if we can't do it, tough. That's really what the amendment is about. I don't think it's unpacking C10-2B. I like what the law book has, but the next edition doesn't have it, and I don't know why, and that could be a floor amendment if somebody so wishes at some point. Are we ready to proceed on the amendments?
Second.
I do need, no, I have one. It was Nelson. So the matter before us is Amendment 2024-1578H to Senate Bill 463. Move ought to pass by DeSimone and seconded by Nelson. Would the clerk please call the roll and call me last, please?
Representative DeSimone.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
No.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
No.
Representative Petrino will vote no. Representative Perez.
No.
Representative Gregg.
No.
Representative Raymond.
No.
Chairman.
And the chairman.
No.
Okay. Motion fails 5-6.
Was it 5-6?
Yeah.
I have 4-7.
2, 3, 4. Oh, 4. You voted no?
I voted no. Yeah, I mean, surprise. Voted with you guys. Yeah, that's no. It happens. You know. Okay, so the amendment fails, brought forward for discussion. It served its purpose. Thank you. Judiciary, you can start recruiting tomorrow. Now the motion before us is the bill itself. S 463. Do I have a motion on the bill itself?
Yes, Mr. Chairman.
Representative DeSimone
I
moves
ought to pass.
OTP. And do I have a second? Like a Democrat. I see a Democrat over there. Representative Gregg. Any further discussion? You may call the roll. I'll go first.
There we go. Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative Bickford. Not here, excuse me. Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Petrino will vote yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Raymond.
Yes.
Motion carries 11-0.
Representative DeSimone, will you write the blurb on that one, please? Oh, look at this.
I don't need it.
No, I do. Okay, I'll read that over and sign off. A couple of things, please, before we adjourn for the day. That concludes the exec session on what we just did. 463. Two things, please, for everyone on the committee. Number one, we will meet next week for at least an exec session on the two bills we did not exec today. And number two, there has been a desire that 498 is recommitted to us. And I really am not in favor of that. I think that is a good bill. We got it out of here unanimously. We have adopted a definition of fictive, which was one of the concerns the person wishing to move recommittal had raised. I think any further churning on who may or may not be, to me, could have some unintended consequences. And the session that we will be voting on this is not this Thursday, but it is in May. And our work should have been done by then. And I am not in a mood to come back just to deal with this being recommitted. So this is not an official vote, but could I have a show of thumb as to who wants this to be recommitted so we can work on it? Oh, well, there we go. I will break the bad news. Thank you. Very nice thumbs over there, by the way. You're all, yeah. And next week we'll see, and I'll let you know as soon as I know, because I got to know by tomorrow afternoon, start a work session on the interim study on restraints. That's, yeah, I believe we can. And if they say, no, not this year, you can't, then I'll let you know that, but I think we can. So we will be here 9:30 next week. Don't know how long we'll be here, but it won't be as long as this. Okay, with that, we are adjourned.